On the record. Good morning and welcome back, everyone. This is the second day of evidentiary hearings for Cranberry Point Energy Storage, LLC, EFSB 21-02/D.P.U 2259. I will once again explain how to use Zoom today to ensure that everyone can fully participate in this hearing. For audio-only participation, attendees can dial in at 646-558-8656 and then enter the webinar ID, which is 875-619-08820. My name is Andre Jabot, and I am the presiding officer in this proceeding, conducting today's second day of evidentiary hearings. As part of the bench today, there are other members of the Siting Board staff: Andrew Green, Director of the Siting Board; Joan Foster Evans, General Counsel of the Siting Board; Wayne Wong, Assistant Director; John Young, Technical Director; and Eric Logan Hughes, Analyst. This hearing is being recorded by a stenographer, and video recordings will be posted to the Siting Board's YouTube channel for viewing. I will again explain the guidelines to use in speaking at this evidentiary hearing. There is a court reporter participating remotely who will transcribe everything said during this hearing. As we are all relying on internet connections or telephones to participate, we could experience some technical problems, such as sound from speakers, including potential background noise, video and audio issues, and potential delays. Please speak slowly and clearly to allow a speaker to finish speaking before you begin speaking, and to pay attention to the video of the person speaking and my video. I will raise my hand as a sign on my video if I need to interrupt the person currently speaking to ask them to stop. May I have appearances of counsel, please?
On behalf of Cranberry Point Energy Storage, LLC, Andrew Kaplan and Paul Connolly, Pierce Atwood, 100 Summer Street, Boston, Mass. 02110.
Good morning. My name is Brian Bertram. With me is Ryan Holmquist. We represent the intervener Save the Pine Barrens. We're of the law firm Miaris and Harrington, 40 Grove Street in Wellesley, Massachusetts.
Good morning. This is Kathy Cuthan. I am here on behalf of NSTAR Electric Company, DBA Eversource Energy, from the law firm of Keegan Worland.
Thank you. Earlier, we discussed the change in the schedule and the addition of a witness by the company, Mr. Kaiser. With regard to the addition of this witness, are there any matters that the parties would like to raise today before we begin with the direct of Mr. Kaiser?
Yes, Mr. Presiding Officer, just briefly, we do have an initial objection given that we understand Mr. Kaiser is going to present testimony based on a revised report that was just submitted a week ago and he wasn't on the witness list. I would suggest, however, that we don't need to rule on the objection presently, that it would be most efficient if you just take it under advisement and if we proceed to see where we stand at the end of that testimony or at the end of the day.
I will take it under advisement. Any other matters that that need to be addressed before we begin today? Mr. Kaplan, are the company's witnesses that will testify today present, and have they all been sworn?
The witnesses that were on the panel yesterday, which are Paul Rogers, Allison Sand, Chris Caranta, and Tom Keogh, and Polly Shaw, are present and have been sworn. We do have the addition of Mr. Kaiser. He has not yet been sworn.
Okay. Mr. Kaiser, if you could raise your right hand, please. Do you solemnly affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please let the record note that the witness has been sworn. Also, let the record note that the witnesses who have returned today have previously been sworn and remain under oath. Quick administrative issue. As per our schedule, we will begin today on time, and we will take a break at 11 o'clock. I mentioned earlier that some of our staff need to be at another meeting at 11 o'clock, so we will take a lunch break from 11 to 12:30 today, and then return promptly at 12:30 and continue on with not only cross, but also staff questions if there are any remaining, and then redirect for the rest of the day. With that, we may begin with the directive, Mr. Kaiser, if you're ready, Mr. Kaplan.
I am. Thank you, Mr. Presiding Officer. Good morning, Mr. Kaiser. Can you please state your name and business address for the record?
Yeah, my name's Chris Kaiser. I'm with AECOM. I'm administratively routed through the San Diego office. Address would be 401 West A Street, San Diego, California, 92101.
What is your position and your responsibilities at AECOM?
My position is Senior Acoustics and Noise Control Specialist. So I'm part of an acoustics and noise control team that do a variety of acoustic studies. Primarily, my specialty is environmental acoustics. So anything that has to do with projects that will generate noise outdoors is where I focus.
Can you briefly describe your educational background, please?
Yeah, I have a bachelor's degree from Columbia College in Chicago. The degree is in the field of acoustics. The broader name of the degree is Audio Arts and Acoustics, but it's a specialized degree in acoustics.
Are you familiar with the acoustic assessment that AECOM prepared for Cranberry Point for this project?
Yes, keenly familiar.
Did you prepare the?
Go ahead.
Did you prepare the assessment yourself or under your supervision and control?
Yes, I prepared the assessment myself.
Do you have a copy of the most recent assessment that was conducted on October 12th-ish? That
Yes.
was submitted in response to EFSB NO-9.
Yes, that is the version I have.
Yes. At yesterday's hearing, Mr. Green asked a number of questions, and I realize you weren't at the hearing. Have you had an opportunity to review the transcript from yesterday?
Yes.
So Mr. Green had asked a number of questions about the noise study, and given that you were the author of the acoustic assessment, perhaps you can respond to those or some other questions that the EFSB or the other.
I'm sorry. I'm sorry. There's some sound going on. Perhaps you could respond to those or some
other questions from the EFSB or the interveners.
Certainly.
So at yesterday's hearing, Mr. Green asked for an explanation of the DEP noise policy and what the statistical case is that they evaluate to determine the 10 dBA increments. Do you have a response to that? Or can you explain that?
Absolutely. So the 10 decibel increase, it's a pretty common impact threshold when it comes to environmental acoustics. It's representative of what would be perceived as a doubling of sound level. So if you were outside experiencing traffic noise and that traffic noise increased by 10 decibels, that would be perceived by the human ear as a doubling of loudness. So a lot of folks use that as their standard for assessing impacts. For example, FHWA, when doing highway noise, traffic noise abatement studies, they usually recommend an impact threshold between 10 and 15 decibel increase to determine a substantial increase in the existing sound level. In this case, as in many cases where we have a threshold based on an increase to ambient, the most important part is what you use to establish what the ambient is. So if your ambient is based on the highest noise level measured throughout a day, well, then your increase to that is going to be much more significant than saying an increase to the lowest level measured throughout a day. So the crux of these increase to over ambient thresholds is really what you identify and define as the ambient, and then also what that allowable increase is. So the way that Massachusetts DEP defines their ambient is the lowest 1 hour L90, in which we could get into the more weeds on what L90 means, but it's basically representative of the background noise level within an area over a given time period, which in this case is an hour. So it's the lowest measured 1 hour L90 across a multi-day measurement period. And then that 10 decibel impact threshold is applied to that value. So if I'm out somewhere for 4 days measuring a fluctuating hourly noise levels, we choose that lowest L90 value. And then we say we could increase during that specific time what that value is 10 decibels above that. So generally speaking, as those noise levels, baseline noise levels fluctuate, we might be at or more than 10 decibels above that lowest point, just generally speaking. But it's during that one quietest hour where we would have that perceived doubling of loudness. Otherwise, I think I've mentioned in comments before that for the vast majority of time, the noise generated by the facility was below or at the just perceptible threshold in between 3 and 5 decibels over the ambient.
So I should have asked, I'm happy to end direct and have Mr. Green or anybody else in the EFSB ask questions directly of Mr. Kaiser. I was going to just go through some of the questions that were asked directly from the transcript yesterday, but if you'd like to jump in and ask questions of Mr. Kaiser, please feel free to do so.
It's certainly your prerogative to conduct direct examination, so we will wait until you're done.
Okay, thank you. Can you turn to table 3?
Okay.
Yesterday, Mr. Green had noted at the hearing I guess let me back up. Yesterday, Mr. Green had noted that assessments are based on modeling that involves an estimation process with math and measurements and that feed into a model. And he was asking, are the predictions that you have listed as part of the acoustic assessment, how accurate are they?
Yeah, that's a great question. The way that the prediction software works is based off of an ISO standard. It's called ISO 9613-2, and that is the international standard for calculating the propagation of sound outdoors. So it takes into consideration absorption from the ground, from the air, temperatures, all sorts of different factors that would affect the propagation of sound. So using that, there's a lot of conservative assumptions that are baked into that standard. One of which is a moderate temperature inversion, which basically means the temperature gradient above the ground is switched. So you have cold air underneath and hot air above. And that essentially traps sound off of the, well, I don't know atmospherically what it is, but traps sound within, so it travels further distances. And then that standard also assumes that all receptors are downwind of the source. So there's an increase that's assumed as a result of that as well. So the modeling results, provided that the inputs are correct, would be relatively accurate, if not quite a bit conservative, probably in the realm of at least 2 to 3 decibels conservative to what would be measured out there in the real world scenario, as long as all those environmental factors didn't align perfectly to that kind of perfect storm of sorts that the ISO standard assumes.
I know that you had done a number of different acoustic assessments. Can you tell me how they came about, how many you conducted, the timeline, the reason for the number of assessments, just.
And the what? And the what?
I'm sorry, Alan, a general overview of the process.
For this project or just generally?
For this, yes, for this project.
Yeah. So the modeling, well, first we established the baseline noise level, and that is through a multi-day measurement survey that we go out there. We deploy unattended sound level monitoring systems that just sit there and measure the noise level throughout the day and a variety of different metrics as well. We conducted a handful of those surveys at our prerogative and also in response to EFSB comments. And the most recent one was conducted during an early spring period where we had the lowest measured noise levels as a result of reduced extraneous environmental noise sources like insect noise. We take that information and we build out the computer model, which considers a variety of inputs, including topography of the area, ground type cover of the area. We use octave band center frequency inputs for noise sources. So when we drop in noise sources, I think all of the ones in this are generally modeled as point sources. The main transformer might be modeled as a vertical area source, if I recall correctly. But those noise sources are assigned a reference sound level that not only includes the overall sound level, but it includes the energy at every frequency band, well, every whole octave frequency band, so that as those frequencies travel outward, they all diminish at different rates, depending on the environment that they're going through. So as the model develops and the design develops of the site, we remodel the project based on the latest layouts, latest designs, as they evolve over time. So this most recent one in October, to my knowledge, was the most recent layout that was provided to us, and that's what we base the modeling on. Hopefully that's what you were seeking in that question.
Yes, thank you. Mr. Green then asked for a high-level walkthrough of the conclusions that you reached from that study. Can you provide that high-level assessment?
Yeah, I'll have to kind of rely heavily on referencing the report here, but generally the noise levels that the project is generating at several property lines just meet the DEP regulation of that 10 decibel increase over ambient. So in some situations, like at R1 and R2, we're actually below by a decibel. Some of them were down by 3 decibels below that standard back at the residential properties. The project generated noise levels appear to range between 37 and 44 at the closest property line, which is PL2. 44 is certainly audible if you're there standing at that corner of the property line where we're predicting that. But that would be a scenario during when the actual facility is in operation. So that means that the fans are on. It's a hot day, and well, it's a hot night because these ambient conditions that we've measured here, for example, at PL2 where we have 44. Well, I should walk that back. PL2 is a very odd property line because it's right up against the Eversource substation. So it by default has relatively high ambient levels because of the existing operation of that substation. It's pretty far away from the actual residents on that property. So it's not really a good representation of the noise in that scenario. But generally, the noise levels are 37 to 40 at other property lines and residences, which during those late night hours might be audible as long as you don't have insect noise, you don't have noise from the overhead power lines or noise coming from the adjacent roadway to the northeast. But that's generally what the conclusions were.
So in turning to table 3, I think that we gave an overall assessment, but maybe we can dive in.
I'm sorry, I can't hear you, Andy.
I'm sorry. Perhaps we can dive into this a little bit. Table 3. Can you actually just walk us through the chart so everybody knows what we're looking at?
Yeah,
And what each of these columns mean?
Absolutely. So the receiver ID, those have a naming convention that is based on whether it's a property line, which is represented as PL, which is the worst case location on that receiver's property line, and then R, which is the receptor itself, which is the residential structure on that property. The next
case, what do you mean? I'm sorry. What did you mean by worst case?
So in some scenarios, if you have a long property line and you have different terrain or different shielding that may be causing the sound to travel in different paths, typically you'd assume that the closest part of the property line is going to receive the loudest amount of sound if it's closest to the source. However, if I have a scenario, and I apologize for the hand gestures here, but if I have a wall right here against the source, well, at the property line, the loudest sound level might be up here because it's not being shielded by that wall. So the way that we assess the property line noise level is we run our noise contours, see where the loudest point is going to be, generally speaking, on that property line, and then we put that property line receiver point at that location. So it's not always going to be right at the corner of a property line. It's going to be based on what we see as where the sound is going to be loudest. And that's normally just within reason. It doesn't have to be exactly at the loudest point, but we just want a good representative location on that property line.
So it looks like you put receivers at 5 property lines and 4 residences. Is that correct?
That is correct. The 5th property line, PL5, is directly to the south of the project. That was just located in a cranberry bog area. We don't have a representative home for that property because there is no residence on that land use.
Okay. The second column on table 3 begins with existing ambient noise level, lowest measured hourly L90. I know that you started to explain L90 earlier, but if you want to go into a little bit more detail, that would be great. And if you can explain what the second column is telling us.
Yeah, absolutely. So the L90 is it's a percentile value. It's a statistical value of the noise level that's exceeded for 90% of a measurement period. So, for example, if we're looking at 1 hour chunks, 90% of a 1 hour chunk is about 54 minutes, I believe. You might want to check that math, but 6 minutes, you have a 6 minute period and a 54 minute period if we want to break it up into 2 periods. Consider a scenario where you have a house next to maybe distant from a highway. And that highway just creates a continuous din of 40 decibels. No matter what, it's always 40 decibels coming to you from that highway. But let's say in that same scenario, you have a road right next to you where trucks pass by on a relatively regular basis, but not continuously. What the L90 does is it takes that 1 hour period, it looks at that quietest 10-minute period where we don't have trucks, basically excludes 90% of the data where you do have the trucks, and represents that quietest continuous noise level that occurred for 10% of the time. So ultimately, if I measured the actual average of that 1 hour period with the trucks, I might have something in the realm of 55 decibels. But if I look at the L90, which takes out all of those individual events of the trucks passing by, I'd get an L90 of 40, which is that continuous din in the background that's always there in the background.
Okay, so can you tell us what each of the findings are? So property line 1, it says 28, and parens LT -1.
Yep.
What
Yeah.
is that
So
telling us?
So each of those values references the measurement locations that were provided earlier on figure 2 of the report. So that's where it kind of identifies where the PL property line locations were located, and also where each of the long-term monitoring systems were deployed, 1 through 5. So in most of these cases, the monitoring system numbering matches up with the receiver and the property line numbering. But there are a few cases, such as R2, where we're actually using the LT1 baseline level. And we use that because LT2 is located close to the substation, which is close to that PL2 property line, where we have those elevated noise levels. But that measurement location at LT2 is not considered representative of the sound level further back in that lot where the house is at R2. So to establish the baseline noise level at R2, we use the LT1 measurement, which in this case is about equidistant from the existing substation as it would be if we had deployed it on that property line within R2. So that's why these numbers don't always, they line up for all of them except for R2, because R2 is using the quieter, more conservative LT1 as its baseline noise level for that home. So these are all the lowest measured single hour L90 across the measurement period, which is multiple days for nearly all of these. And then the next column over applies a straightforward 10 decibel increase to those, which establishes the impact threshold for mass DEP. So it's just a simple plus 10 for the third column over to those values from the existing ambient noise level. The fourth column is just the raw noise generated by the project. So this is the predicted noise from the project, not including anything in the existing ambient. And that's because the noise level limit includes that. So the project only noise level is represented in that fourth column. And then the fifth column, which says compliant with mass DEP noise limit, that just compares whether the fourth column is higher than the third column, or equal to or less than the third column. So because those values in the fourth column are all equal to or less than the mass DEP noise level limit that was defined for each of these receivers, then they were all considered compliant with the noise limit.
Thank you. Tell us what we're saying in terms of a percentage in sound.
I'm sorry, Andy, could you start that sentence again, please?
It was so articulate. I'll try it. Mr. Green asked what this chart on table 3 is saying in terms of a percentage increase in sound pressure when you have a difference between level 30 and 40. What would that difference in sound pressure be?
So an increase in from say 38 to 40 is a 2 decibel increase. Typically in the field of acoustics, an increase of 1 to 2 decibels is not perceptible unless you're in a controlled laboratory environment. The threshold, the bare minimum threshold for being able to quote unquote it's a barely perceptible change, which is a common term used for this, occurs at 3 decibels. So if there's a 2 decibel increase that's heard, outdoor in an environmental setting, that wouldn't be actually perceived as an increase in sound level. It would just be perceived as a continuation of a sound level. If it increased by up to 5 decibels, that's a readily perceptible increase. So that is, oh yeah, I heard it tick up a bit, is what I would say in layman's terms, for that. And then from there, slightly louder until you get to that 10 decibel jump. And that's where you're like, oh yeah, that sounds twice as loud as what I was hearing before.
Okay, is the noise measured at the residence level? Is the noise measured outside the house?
Measured or predicted?
Predicted.
Yes, it's predicted at the closest point to the facade of the home.
Yeah. Would it be less if you predicted the noise level from inside the house?
Yeah, so typically when you're looking at the sound level within a home, there's an assumed transmission loss that occurs when the sound travels either through a wall and windows or through a wall and an open window, and that sound actually reaches the interior living spaces. The assumed values for that reduction vary, but typically you can expect for an open window condition, roughly at least a 10 to 12 decibel reduction. In a closed window condition, usually in the realm of say 18 to I think 25 is also used often for a closed window condition.
So so am I correct then in reading the 4th column when you're predicting the noise generated by the project operation, that looking at the residence, if you are at, let's say R4 is 37, what would the prediction be for inside the house as opposed to outside the house? Yeah,
so for and interestingly, all of the R receivers have 37 as their predicted result. So they're at a minimum with windows open, the interior noise level would come out to 27 decibels, which is probably the lower end of what most sound level meters will actually get you to. Those are the kind of levels that I've measured out in snowy mountains in Alaska, where it's nearly perceptibly silent.
So am I correct that based on the studies done and the assessment that the noise inside somebody's house as a result of the project will be, how would that be perceived by people inside the house?
I think it's highly likely that it would be completely imperceptible inside the home. I think it would be highly dependent on if maybe someone has a home where their window open condition is an entire wall of a sliding glass door and you're essentially opening up an entire wall, then perhaps that would almost be representative of an outdoor exterior condition. But it's dependent on the home structure and those window openings.
So that concludes my direct examination, and Mr. Kaiser is available for cross-examination.
I will begin with staff questions. If EFSB staff have any questions for Mr. Kaiser, we'll do that now.
Thank you, Mr. Jabot. I have a few follow-up questions from the direct examination, if I may, for Mr. Kaiser. Mr. Kaiser, I think you and some of the other witnesses have used the term the quietest hour to describe the sort of L90 statistical notion. It's not, is that actually correct? Are we literally talking about the quietest possible hour of operation, Or is it just simply a statistical measure that 10% of the measurement time would be below that level and 90% would be above?
So the L90 is only being used right now in the context of establishing the ambient noise level. The noise level that we predict is an LEQ, which is basically an energy average equivalent noise level across a 1 hour period. So the L90 is solely used to find that quietest point in the existing ambient environment. And then we're looking at predicting the average sound level based on that L90 plus 10 limit.
So it's 10 dB over LEQ or 10 dB over L90?
It's the 10 decibels over the L90 establishes the criteria that the project has to meet. And to my knowledge, in most of these circumstances, we're predicting the average hourly LEQ against that plus 10 limit.
So you're starting with the 1 hour LEQ as your base and adding 10? That's what I'm really trying to grasp.
No, the existing ambient is always going to be the L90, because that takes if we looked at the lowest LEQ hour that was measured, it would be notably higher, typically notably higher than that measured L90 value for that same hour, because it's considering those truck pass-bys that I was talking about before. So by using the L90 in their establishing of the ambient noise level, Mass DEP is using a metric that's going to ensure, yeah, even at the quietest period where we remove those trucks and we just have that continuous din, that's the point at which we can add 10 decibels, and that's what the projects will be held to.
I think I understand, and let me try to rephrase it and see if I'm correct. So your sampling periods are 1 hour intervals, is that right?
Correct.
And at the L90 level, that 1 hour sample has 90% of your 1 hour samples above it on LEQ for those 90 percentile readings and 10% below the LEQ. In other words, LEQ is a measure of the average hourly sound in each sample.
Yeah, and not to confuse things more, but that 1 hour LEQ is comprised of hundreds or however short of sampling you're taking, a bunch of small LEQs. So that L90 is basically looking at all those measured individual component parts of that 1 hour level, and then statistically removing that 90% of the higher levels and looking only at that 10% of the quieter levels.
Okay. I think I do understand that. So another component of the DEP noise policy concerns pure tones. Are you familiar with that aspect?
To a degree, I don't know it off the top of my head, but that is a commonplace when it comes to noise assessments.
Because you had mentioned your analysis involving different octave bands, and I think that is an element of the DEP pure tone analysis. So again, I'm just looking to see whether your study was showed compliance with that aspect of the policy as well.
I don't know if we discussed that. Typically, pure tone noises, they're kind of difficult to, well, not difficult to assess, but difficult to achieve non-compliance with unless you have a very specific type of project that maybe includes whistling or other types of tonal aspects. Because this project is dominated by fan noise is typically a broadband type of sound where you don't have explicit bands of frequencies that are dominating. But that's certainly something that can be assessed easily for all the receivers to ensure that that's not an issue.
So the fan noise was mentioned yesterday by your colleague, but he also indicated that transformer noise is another significant component of the noise profile of the project.
Correct.
What about the pure tone susceptibility for transformers as opposed to fans?
Yeah, transformers are more tonal than fans, certainly. And so in this type of project, it's going to be dependent on the contributions from each and whether or not at certain receiver locations that the transformer might be more dominant than the fans. From my analysis, it looked like about equal contributions. So I would assume that the fans would, for lack of a better term, smooth out the frequency composition at the receiver point. But that would be something that I'd have to assess in the modeling.
So if we were to ask as a record request for the pure tone analysis pursuant to the DEP noise policy, is that something that would be readily doable?
Yes. I could probably go through and look at it now, but yeah, we could definitely add that in as a secondary analysis.
Okay, good. I think I would like to make that a record request. And before I put that officially on the record, I would just like to poll my colleagues to see if they have any other specifications for asking Mr. Kaiser to perform a DEP noise policy compliant pure tone analysis. I'm looking to Mr. Young in particular.
No, that's fine. I don't think we have to add anything to that.
So let's put that one on as a record request then, please, Mr. Jabot.
That will be RR EFSB -12.
Mr. Kaiser, you may or may not know a lot about past cases of the siting board. You said you're in California, so maybe we're a little bit remote from your normal practice area. But there have been cases where we have specified noise conditions in our approvals and anticipated that a project would follow the modeling results and be, let's say, no greater contribution than X dB over L90 background. And we have in some instances followed up with post-construction measurements to confirm that. Do you have any thoughts in terms of how the siting board could look at a post-construction confirmation of the modeling results that you're presenting?
Yeah, that's obviously different agencies look at project noise in variable levels of scrutiny. Some groups like the Minnesota, for example, their Public Utilities Commission, they require for a wind farm project really substantial post-construction noise monitoring to basically prove compliance beyond just the modeling results. And then those are usually very extensive and kind of not really many other regulations that are so substantial comparatively to that. Typically, we're not called upon to do post-construction monitoring to verify or validate results, but it's not completely unheard of to request those types of things. One thing that's a little tricky when it comes to that is you do need to, depending on the type of project, there are a lot of variables that need to be met. For example, in this case, you'd want to make sure that the fans are operating at their peak condition. You want to make sure that there isn't substantial contamination from extraneous noise sources. How long do you want to measure for? What are the meteorological conditions like? There's a lot of things that need to be met for it to be a valid result if you're trying to really put a nail in it. But that's certainly something that some agencies do require from time to time.
Is it correct that when you're doing the post-construction testing or confirmation analysis, that you actually have to basically shut the project off to recreate the background ambient condition?
Yeah, so depending on the type of project, you might be able to rely on the existing ambient noise level that you'd measured prior. But then there's also on-off test scenarios where you essentially toggle on and toggle off the project noise sources, that you could kind of get those samples of no project with project and look at that delta that's being created.
Is it more accurate or efficient to measure compliance at the source of the noise rather than at the receptor locations, and just use sort of inference to gauge what the receptors would actually experience?
In compliance assessment, the preference is definitely at the receptor, just so that's accounting for any variability in topography, ground cover, any of those things that may affect the propagation of sound. You can, based on modeling, which is relatively conservative, you could define, okay, this piece of equipment can't exceed X dBA at the property line, presuming that if we propagate that out, it ends up being this decibel, conservatively this decibel at the actual receiver point. But when it comes to compliance, the preference is always to be measuring at the actual receiver point, just to have that hard data.
Let's imagine that the project is approved, it's built, it's operating. The board does ask for a post-construction confirmation of the noise analysis. And let's imagine that it, lo and behold, shows that some of the receptors are over 10 dBA over background L90. Let's just assume that for the sake of the discussion. Do you have any thoughts from your knowledge of this facility, what could be done to mitigate the noise under those circumstances?
So in that circumstance, I have experience in wind projects where you might would do what they call is curtail the problem noise sources. So for this type of project, presuming that because the transformer is relatively standard noise level, for the megapack noise sources, there might be a scenario where, and this is looking at source control specifically right now, is perhaps you take that first row of megapacks and reduce their duty cycles so that their contribution is less impactful at the property line than if they were working at their 40% or whatever we had defined in the report. So looking at it that way, you could kind of control those primary contributors by reducing their noise output, depending on if that still allows the project to function at its preferred capacity. And then outside of that, looking at passive noise control, the installation of noise barriers would be the next step in that regard. For this project, I've looked at noise barriers in previous analyses, and because of just the size and scope, it would require quite a significant installation of walls to actually produce a measurable reduction in noise level. So in that case, that would be probably the other alternative that you could go for. I think what's also important is the human aspect. So if you can be exceeding a guidance threshold, but there could be circumstances where the actual resident doesn't mind. They don't even notice it. It's not actually impacting them. And then in that regard, there might be a scenario where there's an exemption or exception or some type of agreement with that homeowner that they're not really affected by it, even though it might be over by a decibel. So there's a variety of different avenues that you can go through if you do measure that in compliance.
I take it you were not asked to look at the question of mitigation for the project. That was not part of your charge?
Yeah, well, for this latest iteration, it was showing compliance, so I did not analyze any type of mitigation because we were meeting the thresholds. In previous iterations, when we were looking at different noise sources and different design layouts, we did have noise compliance issues, and I was designing barriers. So that's why I'm able to speak to the fact that the noise barriers that would be required would be relatively substantial in scope. But for this current design iteration, I've not looked at mitigation measures.
So battery energy storage projects are a relatively new area for the siting board, and I think many of our sister agencies around the country are probably also grappling with this as a relatively new technology. Have you worked on other battery storage projects and had experience post-construction with noise profiles and the reaction of abutters and the communities in general?
I've worked on many battery energy storage projects across the country. I've not done any post-construction monitoring of these projects afterward. Typically, these projects are installed and are a non-issue from my experience, but I'm not familiar with any of them requiring post-construction noise monitoring that I've experienced.
All right, Mr. Chabot, I believe it's getting close to the 11 o'clock time that you had mentioned, and we do have a meeting with the secretary that we cannot miss. I apologize for our hasty departure, but can we take our lunch or brunch recess and come back at 12:30?
That's fine. My computer clock says it's 10:56 right now. As I said earlier, we'll recess for about an hour and a half. We'll be back at 12:30 precisely to start again. So everybody enjoy your lunch and a little extra today.
Thank you.
Thank you.
Hello.
Hello, sir. You can hear us, right?
Yep.
Okay. Can you see us? Because our screen doesn't seem to be, we can't see anything, but we,
I can see the 4 panelists in Cranberry Point right now. Yep, I can see the 4 panelists that are there, so
okay. Let me get that. Yeah.
we've got about 4 minutes.
Okay, thank you. We're gonna try to figure out why we can't see anybody.
Okay.
Good afternoon, Mr. Jabot.
Good afternoon. Okay, that's what I was waiting for.
Made it back.
Yeah, I was just waiting for the break slide to disappear so I can take stock of who's on the screen here. So let's see. We have the panel.
Alan is here.
Yeah.
I am.
Yep.
We have to promote Mr. Kaiser back to the panel as well.
Could you please?
So while we're off the record, I think that I was just about getting to the end of my questions for Mr. Kaiser.
Yep.
I think I may in fact be done. So onward.
Mr. Green, could you re-anoint me a co-host? I'm sorry.
Yeah. I'm surprised it co-hosted.
I believe I was where I left off was if any of the staff had any questions other than what you had done. So if we can just begin there real quick and then we can move on from there to cross if necessary. Or if you know if we're done.
Well, as I said, I am done. I can't speak for the others from the bench.
Okay. Well, it's 12:30. It looks like everybody is here. So we will go back on the record now. And we left off, Director Green had finished his line of questioning, and I invited EFSB staff to ask any questions that they may have. Please let me know if you have any at this point in time.
No, thanks.
Okay, hearing none. Mr. Kaiser, I just have one question for you. Are you available beyond today if needed?
Yeah.
Okay. Have you been made aware of the schedule that the hearings have right now? We're scheduled for Monday and possibly Tuesday as a backup date. Are you available on those dates?
Understood. Let me just verify that. Yes, I'm available both days.
Okay. That's all. All right. Well, it looks to be that the EFSB staff has asked the questions that they need to, and we can begin cross. So, Mr. Bertram, if you're ready.
Mr. Presiding Officer, thank you. I guess because it's fresh in our memories, I'll start with noise and Mr. Kaiser, and I only have a few things. So good afternoon, Mr. Kaiser. You haven't really been in the other hearing sessions, so my name is Brian Bertram. I represent an intervener in this case. And as I just previewed, I just have a couple questions for you. So first, are you aware that there was an acoustic assessment that was submitted with the original petition in this case, and that's dated August 27th, 2021, and has been marked as Exhibit CP-10?
Yes, I'm aware of that.
Okay, I thought so. I saw your name on it. Did you prepare that?
Yes, I did.
Okay, and you have subsequently testified today about another acoustic assessment that's dated October 12th, 2022, and has been marked as Exhibit EFSB-NO-9. You're aware of that as well?
Yes, I can't confirm the exhibit numbering because I don't have those, but I'm aware of both reports you referred to.
That's fair. The exhibit numbers are more for us lawyers when we have to go back through the transcript. So aside from those two acoustic assessments, have you prepared any other assessments or analyses of any kind of noise related to this proposed project?
That is a great question. I'm gonna dig through my files. I know that I mean, this project has gone through many forms over time, prior to it even being called Cranberry Point. So I know that I have, let's see here. Yeah, no, those are the only two legitimate assessments that I've performed for this project.
All right. So you said legitimate assessments. Let me caveat this by saying I'm not interested in drafts, to hopefully put Attorney Kaplan.
Yeah, there are two final reports prepared for the two you referred to.
Okay, thank you. When you testified a little bit earlier, you talked about collecting, I believe, data in the early spring period. Could you just elaborate on what data you were collecting and what early spring period that was?
Yeah, so the original survey we performed for that 2021 report was performed during the summer, and I believe it was in the month of August. Okay. And when we conducted that measurement and went back on the audio data that was collected in unison with the actual sound level decibel data, we could hear a lot of contributions from either insects or spring peepers during the nighttime hour. And that was also reflected in the plots. So if you have that report and you look at the plots, you'll see just at sundown around 7 p.m. 1900, you'll see a spike up in noise level. And that's a result of the sun going down and those spring peepers and or insects creating that elevated noise level during the nighttime period. At the request of EFSB, we went out and we conducted additional monitoring during a non-summer period, where we wouldn't have the contributions from those environmental effects from the existing warmer periods of the year. So we went out again in late March, I believe it's March 24th of this year, where we were able to collect baseline data once more, and that data did not include at least the significant contribution that was observed during the August survey from the peepers and insects.
So your collection of that data concluded in March of 2022?
Yes, it might have bled into April 1st. It was multi-day, so it was late March to early April, the greatest length.
That's what I'm looking for. Okay. And was that data used to prepare the October 12th, 2022 acoustic assessment?
Yes, so the baseline data from which we apply that plus 10 decibel adjustment to arrive at the actual compliance threshold. We use that March baseline data as the baseline for that plus 10 adjustment. When we did this compared to the previous report, when we were basing it off of the lowest measured hour in August, we found that the lowest measured hour in August was roughly 10 decibels louder than the lowest measured hour in our most recent survey in March. Similarly, as you might expect, the quietest hour during that summer survey we performed was actually in the afternoon, because when that sun dropped, the noise level generally was elevated for the entire nighttime period. And then as the sun rose and after perhaps morning traffic flows, the afternoon period was when we had our quietest hour. Fast forwarding to this past March, it's much more representative of a typical baseline character of noise in a one-day period, where you have the lowest noise levels at night, and then you'd see a spike up in the morning for traffic, slight continuation of that during the day, perhaps a spike for traffic noise during the PM rush hour, and then dropping back down to the lowest noise levels for the nighttime period. So yeah, our measured noise levels, say at LT1 back in August was 38. And then when we went back there this most recent time, our measured lowest noise level was 28. So that took all of what we had used for impact thresholds and pretty much reduced that goalpost down 10 more decibels that we had to meet.
All right. I'm trying to keep a clean record for our stenographer here, particularly with the difficulties of Zoom. I appreciate your eagerness to explain, but I'm really just trying to establish a timeline here. So if you could really just answer the question that I'm asking, otherwise we're going to really bleed into our backup day. I'm not trying to be rude.
No problem.
Redirected. I'm sure your attorney will do that. And I don't think I have too many things to ask here. So I just wanted to ask you then, after that, so March to April period, when you collected that background data, did you collect any other data after that time that went into the October 12th, 2022 acoustic assessment?
No.
Okay, so you had all the data you needed at that point.
Correct.
And you just prepared the report after that.
Yes.
And that was complete on October 12th?
Yes. Yeah, that was, I mean, it was, completed and submitted on October 12th.
Okay. Just one second, Mr. Presiding Officer, and I may move on to another topic. Yeah. Okay. I'm going to switch gears a little bit. Mr. Kaiser, you'll probably find my next few questions far less interesting because they don't concern you. I'm not sure exactly which witness on the panel is best suited to address this, and so I'll just address it generally to the panel. I really want to start with just a little background. We've heard some information about different forms of Tesla megapacks, and I just want to make sure that when we use these terms and we discuss these terms, that we're all on the same page so that we don't have confusion in the record. So to the panel, let's start with, are there different forms of what Tesla calls a Tesla megapack?
Over their product life cycle of producing energy storage equipment, there have been various different products that Tesla has produced, correct?
Okay. And so I think, Mr. Quaranta, you sort of hinted at this in your earlier testimony about Tesla doesn't really use the terms XL1 and XL2. Is that correct?
I believe my statement was on the Mega Pack 1 that colloquially gets used. They don't officially brand it that way. It's just called the Mega Pack. The product that they now produce and ship is the Mega Pack 2 and the Mega Pack 2 XL version.
Okay. And so when we talk about a Mega Pack and a Mega Pack XL, those are two different things, correct?
The Mega Pack in their original version was a different battery module, different chemistry, different product than the Mega Pack 2. And I'd say put a slash there, Mega Pack 2 / XL is all basically the same product, just a larger cabinet, so to speak.
Okay, that's what I'm trying to get at. I don't want, confusion on the record. So we have the Mega Pack / you use your term XL1 is different from the Mega Pack, or Mega XL2.
I'm sorry, I didn't hear the end of the question. It's different than the,
the Mega Pack XL2.
I apologize if I'm adding to the confusion. The original product Tesla produced called Mega Pack is no longer produced, but everything that is installed in the industry today and operating, not just installed, in operating, is that original version. Going forward, Tesla is producing a new version. It's called the Mega Pack 2, and then there's an option for it, which just adds another cabinet to add additional battery modules, called the XL. It is identically the same product, except it adds 3 more battery modules. That is the product that we are purchasing, installing, and the updated information on all the IRs will reflect that product.
Okay, that's helpful. That's a helpful explanation. Thank you. So as you just testified, you would agree with me then that can we agree that when we say Mega Pack 1, whether it's XL or not, it's the old technology that is no longer used by Tesla?
That's fine. I'm okay with that. There's no XL version of that, just to be, I guess, complete, but you can say Mega Pack 1 as long as we all know.
I just want to agree on some terminology, so when we look back at the transcript in 3 weeks or whatever, we know what we were talking about. Okay. And if we just say Mega Pack generally or Mega Pack 2, it's what's currently proposed for the project. Can we agree on that?
I would agree with the 2. If you use just Mega Pack, I'm gonna always revert to it being the original product.
Okay, that's helpful as well. That's how we avoid confusion. All right. So I think, as you just acknowledged, and I just want to confirm, when the company originally submitted its petition and analysis to the EFSB, it was based on Mega Pack 1, correct?
Correct.
Okay, because Mega Pack 2 didn't then exist, correct?
It was in development and was not a released product at that point in time, correct?
Okay, and that gets me actually to another question. If I could have you flip to what has been labeled as exhibit STPB 1-1. I'll give you a moment to go to that, and then you can let me know if you're ready.
Yep, I'm there.
All right, so if you look at the response, little a, second sentence, you wrote as anticipated. Is that what you mean when you just previously testified that you guys expected that Tesla would have a new model at some point in the future?
So as anticipated,
I think you're at 1. He said 1-1.
Yeah, 1-1.
Oh, okay.
Yeah. So we had expectation that and knowledge in working with Tesla that they were transitioning or beginning to transition to a new product line. And by the time that we would purchase the system and install it, that we would be installing the Mega Pack 2 XL.
Okay. So that understanding or anticipation was based, at least in part, on conversations with people who worked for or represented Tesla?
It was based on their produced documentation and was based on likely general conversations about product roadmap that all suppliers would provide to us over time.
Okay. Did you disclose anywhere in the petition or analysis that you anticipated that the battery technology would change to Megapack 2?
So I would have to confirm with exact wording, but I do believe in the petition, we talk about the fact that technology like this does evolve. And when you look at the extreme extended period of time that this process goes through, it would be expected that that technology could and would evolve, and you would adapt to that as time goes forward.
All right, well, we have what's in the in the petition. At what point in time did the company make the decision or learn that it had to change to Megapack 2?
I would have to dig to be exact in that response.
Mr. Presiding Officer, can we make that a record request?
That would be RR STPB 1.
Can I ask a clarification?
Yeah,
So just in terms of that clarification, can you define what you mean by that decision point? Because I doubt it was an exact moment, an instant in time where that was a black and white decision. It is likely an evolution of product knowledge and information that comes from all suppliers as they, continue to improve their product. So I just want to make sure I understand what you're looking for.
well, let me ask you this, and maybe it'll help us clarify. If you wanted to install Tesla Megapack 1 today, could you?
At this point in time, no.
Okay, so there was a point in time when Tesla discontinued the product, is that correct?
I honestly do not know if they issued a discontinuance or not, but I would expect there's a date where it was no longer available for sale.
Okay. Well, I think in terms of the record request, what I'm looking for then is the company's best explanation about when it was reasonably certain or made a decision that it's going to change to the Megapack 2.
Certainly.
All right.
Thank you.
Was it before or after this summer, 2022?
I would have to go back and confirm. I would have to go back and confirm.
So sitting here today, you don't know. Was it close to this summer 2022?
It was probably prior to summer 22,
Okay.
subject to my verifying it.
So when we talk about summer, prior to June 2022,
Sure.
does anybody else on the panel have any opinion on that, or is it just Mr. Quaranta? Ms. Sand, do you know? You're the project lead.
I think this was actually asked as a record request, so.
Yeah, I've moved on in my
get the
question.
answer as quickly as we can.
Well, Mr. Presiding Officer, if you want to rule on that, but it sounds to me that I'm getting additional information on this.
Well, if it's in the form, are you making a record request to have that date provided to you, or do you want it included in the previous record request? Do you want another record request?
No, I'm satisfied with the prior record request. I'm just trying to do a little questioning around that now to see, now that we have the witnesses live, what best we can establish while we're here. Understanding it perfect.
If council is currently looking up the record request to see what their response was, you may have an answer forthwith. I'm assuming that that's what Mr. Kaplan is in the process of doing right now.
All right. I just have a few more questions on this line anyway. So I would like to re-ask the question now, though, to Mr. Quaranta or the panel. Is it your belief that it was prior to June of 2022?
It is my expectation that it was prior to June, sure, yes.
Are you aware that there was a public hearing that was held on this project in July of 2022?
I would expect I am aware of that, yes.
Okay. Was there a version of the petition or analysis that was filed with the EFSB that referred to Tesla Megapack 2 at the time in July of 2022?
Yeah, I'm not sure I understand what you're asking. Are you trying to,
If someone
so
looked at
the public
petition-
hearing, the public hearings.
Sorry. Mr. Quaranta, if you had something you wanted to say, I don't want to talk over you.
No, go ahead.
Well, I'm just trying to ask. So there's one petition and analysis that's been submitted in this proceeding, correct?
There's a petition that was submitted that was the 69J and a quarter. And then there was an addition of the 40A, I believe, is the right way to describe it.
Okay, that's fair. So just to add a little more clarity to this, Cranberry Point Energy Storage submitted a petition on August 27th, 2021, correct?
Yes.
Okay. And that was supported by what is labeled in the document that is, one second here, labeled as an analysis in support of petition. Is that correct?
Yes.
Okay. And in that analysis, is there any mention of the Tesla Megapack 2?
I would have to go pull the, I can go pull the petition so I can read it and be accurate if you'd like.
I think we've gotten out of this. We want to get out of it. So let's talk about Tesla Megapack 2 for a minute. I just want to make sure, I know we had some testimony on this the other day. How many enclosures are proposed currently for this project?
82
82.
for the Tesla Megapack 2 XL, to be clear.
Okay. That it's like almost like an off the rack product, if you will. You get it in that form.
Yeah, it's not completely commercial off the shelf, but yeah.
Okay.
I just wanted to be clear in terms of other enclosures that might be on site and things like that when I gave you the number.
Okay. Would any other enclosures on site include a battery cell other than the 82?
I would expect, yes, the network enclosures will include a universal power supply, typical in all server communication equipment that would have batteries in them. Those are typically either nickel metal hydride or lead acid batteries. I would expect that there are backup batteries in the fire detection system. I would expect there are backup batteries. Actually, there will be backup batteries in the EverSource substation for backup of all the protection and control equipment. And at least without looking at any engineering design drawings, those are all of the batteries that I can think of off the top of my head.
Okay. So let's return then to the 82 enclosures that you just spoke of. Just remind me again, how many modules are in each enclosure?
There will be 24 modules in each enclosure.
Okay. And how many battery cells in each module?
So to answer clearly, there are 3 submodules, for lack of a better term, that are combined into one physical field replaceable unit, or FRU as Tesla describes it. That's what there's 24 of. And in each module, which is that grouping of 3 submodules, there are 336 cells. So to do the math of where you're going, it's 8,064 cells in one Megapack 2 XL enclosure.
Okay, all right. Thank you. You want to go for that?
Good afternoon, Mr. Presiding Officer. Good afternoon, everyone. To reintroduce myself, I am Ryan Holmquist, and I have some questions about, I would like to start with questions about the various UL 9548 tests that were performed. So I believe these questions are still directed to Mr. Quaranta. So first, Mr. Quaranta, there was the first test performed was a cell level test, is that correct?
Yes,
Do you know about when that cell level test was performed?
I believe the date is on the UL 9548 cell report. I don't recall it off the top of my head. I can look it up if you'd like.
That's okay. I think if it's on the test, that's fine. But that was first in time before the module level test. Is that correct?
It is.
So thank you. So there was a module level test performed. And do you know, I imagine it's probably about the same answer. You don't know off the top of your head when the module level test was performed.
I don't have an exact date, but I'm sure we can get the details if that's what you'd like.
Is the module level test in the record? Has that been filed in this proceeding?
The module level test is summarized in the HMA. It is not a separate record at the moment.
Do you have a copy of that, Mr. Quaranta?
The HMA or the full module level test?
The full module level test. Does the company have a copy of that in its possession?
It does.
Okay.
Would you like the date?
Sure, please.
December 20th of 2021 is the date for module level test.
Mhm.
And November 12th of 2019 is the cell level test report.
And were both of these tests performed on the Megapack, the cells that would be used in or modules that would be used in the Megapack 2/XL?
Yes, they are.
And then finally, a unit level test was performed, correct?
It was.
And that is in the record as attachments to STPB1-1 and STPB2-1, correct?
Without looking at them, yes, I believe those are the right numbers.
I will.
And that is the unit level test report.
Yes. Okay, so I have some more specific questions about the unit level test report. So if you could go to that STPB1-1 test report.
Yes.
Thank you. So does this report document a test that was performed on the Megapack 2XL?
It does.
Okay, can you go please to the 4th page of the report? The last
Yeah. I'm assuming.
paragraph on that page
Yes.
says that MP2XL uses the same batteries, converters, vents, and sparker system.
I'm sorry, I can't hear you when you're looking down.
Sorry. MP2XL uses the same batteries, converters, vents, and sparker system used in MP2. The enclosure is of similar construction to that of MP2. Key difference in the two models is that MP2XL contains 24 AC battery modules.
I'm sorry, the key difference in the two models is that
MP2XL contains 24 AC battery modules instead of 19 in MP2.
Yep.
So does this indicate that the test was only performed on the MP2, but not the XL version?
So what this indicates, and I'd like to correct myself, I obviously did my math wrong. There's 19 to 24 modules, so that's a delta of 5 in the one cabinet, not a delta of 3. My mistake for not looking at it accurately. In addition, to answer your question, what the nationally recognized testing lab at TUV Rhineland is saying is that it's their expert opinion or their assessment that doing the test on the Megapack 2, which is the smaller cabinet, which would have a smaller volume and collect gas more aggressively than in the Megapack 2 XL, which has a bigger cabinet, satisfied the requirements of the test against the UL 9540A standard for unit level test.
Okay, so just to be clear, this test was actually performed using a Megapack 2 or an XL?
It was performed using a Megapack 2.
Okay, thank you. About that, sorry, one moment. When did you first inform the Carver Fire Department that the project would be using the Megapack 2 XL instead of the original Megapack?
I would have to go back through documents to confirm an exact date. I know we have spoken with the Carver Fire Department since at least my employment with Plus Power in context of this technology evolving over time, and that the exact product that we may talk about at one point in time may evolve or improve as product enhancements and improvements are made. And they were well aware and understood that evolution in the product.
Going back to the unit level tests that we were discussing, is it your opinion that the UL 9540A unit level test tested a worst case scenario by applying film heaters to 6 cells? Is that right?
That is what's been deemed by the UL Standards Committee as a credible worst case test scenario that is repeatable and reproducible, yes.
How is 6 cells determined as the number of cells to test?
I can only speculate on what the 30+ member committee that developed the test standard based of a new number of fire professionals, industry professionals, fire departments, etc., may have come to conclusion on. But if you'd like me to speculate or give my opinion, I can.
Sorry, did you have?
So you say it's in the standard, 6 cells, is that correct? Can you give us a citation for that, please?
I didn't say that.
So, well, then could you?
I said I can't speak to why the determination of the standards committee was to decide what the test conditions might be. The 6 cells, I believe the point is in the test standard, I would have to pull that and record it. I mean, pull that and review it, is that you need to create enough of a heat generation in existing cells to cause the additional cell to go into thermal runaway. So whether it's 4 cells, 2 cells, 6 cells, 20 cells, it wouldn't make a difference. The test condition is to force an additional cell to go into thermal runaway. So my expectation is when they did 1, 2, 3, 4, or even 5 cells all co-located together, they still could not get a 6th cell to go over, sorry, up to 6, could not get a 7th cell to go into thermal runaway. And it took the grouping that's shown in the test report to finally get another cell to go into thermal runaway.
But just to clarify then, and I want to be clear, the test standard itself doesn't specify a number of cells, correct?
I do not believe it does without looking at the standard. Paul, do you?
No, the test methodology says that another cell must go into thermal runaway. So how many cells it takes is up to the design people who have put the module together. So as Mr. Caranta said, if you have 2 cells that propagate to another cell, then that's all you're going to need is the 2 cells. If you have 10 cells that makes it propagate to another cell, then you're going to have to test it with 10 cells to make that other cell go into a thermal runaway event. Hopefully that clarifies.
It does, thank you. The report that we have, this is the report of a single test, correct?
The UL 9548 test, as an example I like to use, should be thought of as similar to the bar exam or a medical exam, where you do a tremendous amount of engineering and effort leading up to that one culmination test to verify results. That's the normal practice of many of the UL standards that protect the safety of all the products we use today.
Okay, but it was only, the report presents the results of just, it sounds like, yes, one single test that was run.
The report itself that TUV Rhineland documented was a single test event of the entire enclosure, yes.
Okay. Thank you. Let's see. I think that is all my questions on the UL report. I'd like to go now to the HMA, which is the attachment to EFSB S-37.
One moment, please.
And it looks like several of you contributed to preparing the HMA perhaps. So whoever is the most appropriate to answer these questions, please do. So HMA stands for Hazard Mitigation Analysis. Is that right?
Yes.
Can you please explain what an HMA is and what its purpose is?
Sure. Paul, I'd ask if I say anything wrong, you want to step in as well. But the idea of the hazard mitigation analysis, and it is documented as one of the processes to follow through the NFPA 855 standard, is to go through and look at a series of potential hazards and to look at both the causes or the events and the threat that does occur or could occur, and then the consequences of that event. And it is a common tool used in fire protection engineering in the fire services to look at potential hazards and how to manage them and deal with them.
Thank you. So this version of the HMA that we're looking at, this concerns the Mega Pack 2, correct?
Megapack 2 and Megapack 2 XL, since essentially they are the same product.
Understood. Was a version of the HMA prepared for the original Megapack that was proposed to be used in the petition of this proceeding?
It had not, because the normal practice of doing an HMA is typically during the later ends of the design phase of the project, such that you're informing the HMA with all the design details that you're incorporating into the project. So when the petition was first submitted, at that point in time, there was no HMA developed because there were a lot of design details and engineering details around the project as a whole that were still not finalized.
So if you could turn briefly to section 5.3 of the petition. So let me know when you're there.
Yeah. Okay. One moment, please. Sorry.
Take your time.
Okay. Yep.
Okay, so the second paragraph under 5.3 starts per the manufacturer's hazard mitigation analysis. So is this different from the HMA that was submitted with EFSB S37? The one we were just talking about.
Yeah, this is referencing, in general terms, the recommendations of the manufacturer, Tesla.
Could you clarify, Mr. Quanter? You said it's referencing the recommendations made by Tesla. I believe the document says it's an HMA. So did Tesla prepare an HMA or not?
They did not, to my knowledge, produce actually, let me restate that. I would have to go back and confirm if it was actually documented as an HMA, if it's their emergency response plan and guidelines, and this is misquoted.
Can we
I'd have to
agree that
confirm
an
that.
emergency response plan and HMA are different documents?
We can agree that they have different components to them, yes.
Are they have different components and each is required by different standards, correct? Or maybe this,
They have different components, they have similar components, and they are required by different standards, so to speak, yes.
okay. And so you're required to have both an ERP and an HMA, correct?
Actually, you're required to do what the AHJ tells you to do and what they require. So if you go through the 855 process, the AHJ could, although I don't think they would, say that they have no need for an ERP and no need for an HMA because they understand whatever the product is you're installing. But that is at the discretion of the AHJ. They are recommended. And again, Paul, correct me if I'm misstating anything. I don't know that they're an absolute requirement, but they're obviously very general practice and normally used, but it comes down to the discretion of the AHJ.
All right, but they're general practice, they're normally used. And the fact of the matter is we now have an ERP and an HMA as separate documents for this proposed project, correct?
Yes, we have produced a draft ERP and a draft HMA.
So if you referred to something as an HMA in a prior document and it's not an HMA, that is an error, correct?
So I guess you can quote me on a typographical error of the terms that are in lowercase on the second paragraph of page 34 in section 5.3, sure.
Well, if I started asking you about the ERP as the HMA in this proceeding, you would say that they were two separate documents, correct?
As we've provided them as response to the EFSB IRs, yes.
All right.
Okay, so back to the latest HMA, the HMA. This was produced on October 20th. So last Thursday, is that correct?
It is.
Okay. Has it been shared with the Carver Fire Department?
It has.
When?
I would need to check the exact date, but I believe it was the day we received it, probably the 20 or 21st. I can confirm. It's the 20th, right? Yeah, probably the 21st
Of
October, I'm sorry, 2022.
Okay. Did you share any drafts with the Carver Fire Department?
This document is the draft that we shared with the Carver Fire Department.
Okay, so that was the first time that they had seen the draft HMA was on the 21st, is that correct?
That is correct.
When do you anticipate finalizing the HMA?
As we complete design,
Which will be,
dependent on the completion of this hearing.
so the HMA won't be finalized until after this, you expect until after this proceeding is complete?
It will not be finalized until no, because it'll include any particular details or elements of the design as the design gets finalized into the IFC drawings.
Okay. How often do you expect to be in communication with the Carver Fire Department about the draft HMA?
I would expect, I don't mean to answer it abstractly, but I would expect as often as required.
I'm sorry. I'm sorry. I didn't hear the beginning of that. I would expect they'll need to answer what?
I said I don't want to sound like I'm being too abstract in my response. However, we will work with the Carver Fire Department as often as necessary. So any major changes, any new documents, any design milestones, things of that nature that would initiate a sharing of information or documentation relevant to the design that they oversee as the AHJ for that section of the project.
Okay, thank you. So now I think I'd like to go on to the ERP. Oh, okay, sorry.
Sorry,
Ryan has,
I'm gonna inject myself back into this, and I think that
No problem.
Mr. Caranta, it seems like you're the one who's on the hot seat today.
Probably not the last time.
Yeah, well, I guess it comes with the territory, right?
It does.
All right. So I think you previously, when we were talking about the difference between Megapack 1 and Megapack 2, I think you mentioned, but I want to confirm, is it your knowledge, your belief that there are currently no facilities that are actually operating right now using a Megapack 2, whether it's XL or not, technology?
So information in this industry is typically not as publicly available as one might normally expect. There may be a project in commissioning. I don't know that I'm aware of any project that is in full operation at this point in time.
That's fair. So I guess to put a collar around that a little bit, you're not aware of any, correct?
Correct.
Okay. And so I guess the natural extension of that is that, so Cranberry, let's do a foundational question. Cranberry Point LLC is the proposed applicant and operator of this project, correct?
Yeah, I believe that's the right. Yeah, yes.
And that Cranberry Point Energy Storage LLC is a subsidiary of Plus Power. Is that correct?
That is correct, but please, if I'm getting the company lineage wrong, correct me. But yes, I believe so. Sorry.
That's correct.
And so to your knowledge, Plus Power is not currently operating any battery energy storage system using Megapack 2, correct?
Not currently operating a Megapack 2 or 2XL system, correct?
Okay, and let's take that the next step then.
Yep.
This project is proposed to use Megapack 2. Does Plus Power have any other projects that are currently proposed to use Megapack 2?
Yes, we have a project that's public that is undergoing construction right now in Hawaii, on the island of Oahu, with HECO as the customer, Hawaiian Electric Company, that is installing the Tesla Megapack 2 XL as the equipment to provide the energy storage functionality.
So we've got one other project for Plus Power that's going to use the Megapack 2 that you're aware of, correct? That you're aware of.
I don't want to be exact. That's the only one that's in construction that will use the Megapack 2 XL. I believe there are some later stage projects that we may be targeting, but I'll be, again, blunt in the sense that the supply chain situation and everything else going on in the world today kind of takes that control out of our hands a little bit with each, project as we get towards the construction phases.
I think anyone who is at all involved in construction or law around it appreciates that sentiment. So when you testify today, Mr. Caranta, your sort of testimony about Tesla Megapack 2 is based, well, let me withdraw that and rephrase it. Your testimony today is not based on any knowledge you have about a battery energy storage system installation that is currently operating with Tesla Megapack 2. Is that a correct statement?
Yeah, that's a fair statement. That's a correct statement.
All right. Can I get you? So I'm going to ask you actually to make this next part a little easier to pull out two documents and have them in front of you. The first is what's been marked as exhibit STPB 1-51. And I'll let you find that one and then I'll tell you the other. Do this.
Yep. Just one moment. It's a large book.
There's a lot of exhibits, I understand.
Why do I not have 51?
Because you didn't answer.
One moment. Actually, you want to give me the second one if you don't mind, just to make sure.
And if it's, I don't know how you're organized. If it's helpful, the first one that I'm asking about, the respondent is actually counsel.
Oh, okay. And that's, yeah, I don't have a copy of that. I'm sorry. Yeah, okay. I see the question. And yes, you're right. Obviously, we did respond counsel, so that's why it's not in my book.
I don't know.
That
Oh,
makes
sorry.
sense. Like, I don't know how you organize that, so I just wanted to make that.
Yeah, sorry. Give us one moment. Apologies. What was the second one? Sorry, while they're doing that.
Just your pre-file testimony.
Okay.
For the transcript, that's exhibit CP-CQ-1.
That one I got.
All right. About halfway down the page of your testimony, starting at line 11, you wrote, "We looked at products that had safety systems in place to prevent thermal runaway." And then you write some more too. So is it a fair statement that you looked at different products other than the ones offered by Tesla? If you need to take a moment to read the testimony, please feel free.
No, yeah. We did look at other products, yes.
Okay. And if you refer to exhibit STPB 1-51, since it was answered in the first instance by counsel with an objection, I'd actually like to refer this to the presiding officer first. The objection was that the EFSB is not evaluating potential batteries. I would address to the presiding officer, it seems pretty clear in his pre-filed testimony that he actually spoke about different batteries. And so I would ask that I be allowed to address the question that was objected to the witness at this time.
I'll hear from counsel from Cranberry Point.
I have no objection to that.
Given that there's no objection, I'll allow you to pursue that line of questioning.
Okay. Mr. Quaranta, rather than read it, I think you can read STPB 1-51. And when you're done with that, if you could give me a response, I would appreciate it.
Sorry about it.
I'm sorry, is that 1-51?
Yes, 1-51.
Thank you.
Yep, okay. I'm gonna leave it there for 1 second, sure. Yeah. Yep. So I've read it, I'm good.
Okay. So the information request itself is a question, starting in the second sentence of the question. Could you just answer that now is, I guess, my question.
So as part of the overall process in developing one of these projects, we always look at a number of different technologies, similar to what I just mentioned, you know, for constraints around supply chain, constraints around the evolution of technology. For reference, I think the original interconnection documents for this project went in, I believe, 2019, maybe slightly earlier. So we're talking about a span of, you know, multiple years. And in this industry, the products evolve pretty quickly in terms of their specific details and characteristics with product improvements and things like that. And I say that as background that, yes, we did look at different products. I believe for this site, because of the size of the site, the layout of the site, that the Tesla Megapack 2 XL product was identified as, and even originally, when the petition was filed, the viability of the Tesla Megapack 1 or Megapack were both the strong lead candidates that we would go forward with. In most projects, we typically would hold definition of that exact detail for some time in the design phase, even because of some of the different constraints that occur. But because of the process and the way we needed to go through it here with the EFSB, that's why we made some of the decisions we did in terms of the product definition.
When you chose the Tesla Megapack, was that decision based at least in part on your view of its safety features?
Yes.
Would that have been a significant part of your decision?
It certainly would have been at least 50% of a decision, roughly.
And at the time it was, so I just want to be clear, because it sounded to me like you said when you made the decision, you were contemplating Tesla Megapack 1 or Megapack 2 at the time you put in the application. Is that correct?
Yes.
So you were aware of Tesla Megapack 2 at the time you put in the initial petition. Is that your testimony, sir?
So aware that Tesla is improving their product? Absolutely. Did I have committed delivery dates, timelines, or even availability? No.
What did you know at the time you put in the petition about how Tesla was improving its project or its product, excuse me?
I can speak in general terms. I can't tell you exactly what was on my mind on the date the petition was submitted, but in generalities, sorry.
I was going to say, let's start with general terms, and if I have follow-up questions, I'll ask them.
Sure. So I guess if you don't mind a touch of background, you know, prior to being at Plus Power, I spent 10 years working for a company that developed a product that was competitive to Tesla. at NEC and A123 systems.
I'm sorry. I'm sorry. At what? At NEC what?
NEC/A123 systems. First company went bankrupt, got sold, changed to another company. Long history. Sorry. And that the product evolution is pretty continuous in terms of upgrades to the cell, to BMS technology, to the product, enhanced safety features, new regulations, all those sort of things. So when we originally looked at, product offerings, we would have both insight and expectation of product improvements. I can tell you in my 10 years, for example, in previous companies, the exact delivery dates and product availability dates and ramp dates of volume move around a significant amount and can't always be counted on. And so, even if we had knowledge of the Megapack 2 development, there would have been no financial or no commercial way to kind of commit to a developing product. And therefore had to be comfortable with the Tesla Megapack 1 as well as a solution, if that's where it became.
Would you characterize the Tesla Megapack 2 as a significantly different technology from Tesla Megapack 1?
I think it would depend on your definition of significant, and I don't mean to be difficult by that.
Well, let me ask you, how would you define significant? Let's start there.
I would define significant as like a revolutionary architecture change, like a innovative product. And in that case, I don't see it as a significant change. I see it as more of a derivative change. Again, from my opinion, in some ways, the exact battery that goes into the system from an electrical perspective, just talking about that specifically, it's a battery, right? A lot of the controls and the architecture for those things are what are important. And a lot of that is consistent going from Megapack 1 to Megapack 2. There's definitely enhancements in the products. Okay, sorry. Enhancements in the product as it goes between. I think there are advantages to the Megapack 2 XL now that it's where it is, and we've seen some of the data in that regard. I think at the end of the Fisher report on the last page, it does a really good job of breaking down the differences between the two systems, but I still think, if this is what you're asking, that the Megapack 1 is still a solid product. I don't think of the Megapack 2 as a major change going forward. I think of it as a enhancement.
Okay, but so if it's not a major change, it's a non-major change.
Sure.
When you say it's an enhancement, what do you believe was enhanced in the Tesla Megapack 2?
So from a product perspective, I think I'm good with that. And if it helps, like I said, there's a good breakdown in the Fisher engineering report. If we want to look at that, that's where I am. Sorry. Thank you. On the very last page of that in the appendices, it has some documentation on the Megapack 1 versus Megapack 2. The Megapack 2 does have a different chemistry that it utilizes, a LFP-based chemistry versus the NCA or NMC-based chemistry. There's some changes in the size, dimensions. There are some integration of how they packaged things together mechanically, and they've made some changes that I think from a manufacturability perspective make the Megapack 2 XL and Megapack 2 more easily manufactured in a volume sort of scenario than where they were with Megapack 1.
All right, so the one thing then is the battery chemistry is different between Megapack 2 and Megapack 1, correct?
Correct.
Would you characterize that as a significant change?
Probably based on the number of years I've been in this industry, no. I started using LFP back in 2011, 2012. A lot of the industry shifted to using other chemistries. And, you know, for a whole host of reasons, I won't even try and describe, the market has kind of slid back, at least from not slid back, sorry, moved towards using LFP primarily in energy storage systems at this point in time.
Is it a significant change with respect to safety?
I think it's different, is the better way to say it. I think it has definite advantages, but I don't know that I would say, yeah, I think I would honestly say it's different and has advantages in terms of some of the stuff that we've highlighted in the IRs, as well as what's very clear in the UL 9548 test report in terms of how the cell performs. It does not have the same density as NCA or NMC, you know, so from a per unit volume perspective, you can get, in simple terms, a more powerful megapack using that other chemistry. But yeah, that would be my summary.
I may give you a break for a moment, Mr. Carranza. So if you want to get some water, I'm going to shift gears here a little bit.
I appreciate that.
I don't think you're the sponsor of the alternatives portion of the application or the petition and analysis. So I think that's Ms. Sand. Did I get your name correct? Okay.
Yes.
All right, very good. So I actually, just to make sure I remember this correctly, in terms of the alternatives, there were 3 reviewed locations. This one in Carver, one in Falmouth, one in Wakefield, and then there was a no build scenario. Is that correct?
That's correct.
Okay. So can I get you to turn to what's been marked as exhibit STPB 1-54?
Yes, I'm there.
This isn't a memory test, so if you want to read this quickly and when you're done reading it and you've refreshed your memory, if you want to look at me. So the question asked for copies of documents, and you referenced using GIS data, land records, and public information. But I don't see any documents attached to this response. So I just wanted to clarify, does the company actually have in its possession copies of documents that would concern this question?
We have documentation related to the development work that was done on these sites until a point in which Falmouth and Wakefield were no longer viable alternatives. But the documentation related to citing these projects is is data that is referenced during a citing process and not necessarily taken as a copy, if that makes sense. So looking through GIS data or land records is something that is done in that process, but not something that is taken as a copy.
Right, I understand that, but I guess I'm interested in where in the response we were told that you possess documents and you weren't turning them over.
May I interject and ask? Wrong mute button. Was the question about some of the documents that we were reviewing that led us towards Southeast Massachusetts? Because that's a simple one, and the state of charge issued in 2016 was directly focusing storage deployment in the Southeast Massachusetts area. And we'd be happy to turn over that document if we have not already.
Well, I think the question stands if there were documents in the company's possession and we asked for them in discovery and the response did not attach documents and did not indicate that they were being withheld. Well, I'm not going to say that. Where in this response does it indicate that something was not being withheld and on what basis? Because now here we are at the hearing.
Can I ask for clarification what kinds of documents you're referring to? Because the question is rather large. If the question was about documents that led us to look at Southeast Massachusetts, then it was perhaps an oversight that we did not submit the state of charge report. That would be one contributing document. We could provide it
Mr.
now.
Bertram, if you can give me clarity on what document specifically you're looking for, we can take that back and review what we have.
My question right now isn't looking for clarity about the documents I'm looking for. I'm just asking, is there a statement in the response that would indicate to me that you were unclear about what documents you were supposed to produce to me, or that you had documents that you were holding back that you thought were called for by this question? Because there's nothing in the response as I read it, and I'm giving you an opportunity to answer, that tells me that.
We didn't
Again,
clarify
we'd be
that we
very
had.
happy.
Wait. We have two people talking at once. Sorry, could you begin again, Ms. Sand?
I'm going to intercede here for a minute. Ms. Shaw, if you can just wait until either Ms. Sand answers or vice versa. Just, we can't have everybody talking over each other. Thank you.
Mr. Bertram, we were referencing the documentation we used that was publicly available by giving clarity as to public records that we utilized, like GIS data, like land records, like publicly available maps, etc.
Ms. Shaw, if you want to add something, you may do so now.
Thanks. The question about documents is very broad, but if the state of charge, for example, is a suitable document that answers the question, we'd be happy to turn that over now.
I'll move on from this line of questioning, Mr. Presiding Officer, but I would just like to note for the record that I think everybody who's an attorney on this call appreciates that getting documents in advance of a hearing, as opposed to getting clarity during the hearing, can be a different thing.
Noted.
All right, let us turn to what's been marked as Exhibit STPB-155. When you have that in front of you, please let me know.
I do.
Okay. All right. In response to this question, you cited the same, I think the same generally available resources when you identified these alternative locations. Can you explain to me, when you start with this analysis, do you start with a list of more than just the locations that you settle on and then you winnow it down, or is there some different procedure for this?
Yes, so during a siting process, given in a particular location, and my colleague Polly Shaw can go into specifics related to why Massachusetts was originally targeted, and more specifically, the Boston and southeastern parts of the Commonwealth. But during a siting process, there are several different factors that come into play into an analysis of what projects to move forward with, and which projects or future project sites could be viable or not viable. So the 5 major components we listed are key aspects that we consider when reviewing sites. So because we are looking at a variety of pieces of property located adjacent to electrical infrastructure, reviewing available transmission capacity for those pieces of property, yes, there are several different pieces of property that get looked at. It could be something as simple as recognizing that a substation that may electrically make sense for a project doesn't have adequate space nearby to move forward with looking at that piece of property, and it could be dismissed nearly immediately. On the other hand, it could be a situation where we review land records, we review property information about a parcel that is adjacent to infrastructure and might have available transmission capacity, and start to look at environmental mapping to understand, does this parcel of property potentially have any floodplains, any wetlands, any cultural resources that are publicly identified? And if there's significant concern from an environmental perspective, then that site could be dismissed as well. So it definitely is an iterative process to try to locate the optimal site for a battery project.
All right, so when you say it's iterative, is it fair to say that you start with a whole bunch of sites, and as you go through iterations, you narrow it down, and you finally arrive at your selection?
Yes, you look at several sites to try to find the optimal site.
With respect to this project, did you look at sites in addition to Carver, Falmouth, and Wakefield?
Other pieces of property in the explanation I just gave as to how locations are identified on the electrical system or adjacent to the electrical system are briefly looked at and considered and dismissed if from a certain angle they're not viable. So we did not only look at 3 pieces of property to get to the 3 pieces of property, but the reason that these are alternatives and that the Cranberry Point project is the preferred selection is because these projects were in development under a thorough due diligence process to understand the viability of each site.
And you said there were 5 factors that you typically look with. Who came up with
So those are, sorry to interrupt you, Mr. Bertram. Those factors are major contributors. There are other factors that are taken into consideration, but those are major considerations for a battery energy storage system. And we put, this list was put together by myself and our team.
Okay. So is it correct then that there are other factors than the 5 major factors that you listed in your response that go into a decision?
Yes, there are other more minor factors. This is this process takes a very holistic approach, and there are complexities and elements related to power plant development that do come into play beyond the major 5 that we listed.
So one of the factors that's not the major 5, could one of those factors standing alone actually eliminate an alternative during the analysis?
Yes, the unique thing about development of battery storage and any other power plants is if all factors that are required to make a project successful aren't available or present, any one of those could render a project not viable. There are many pieces of the puzzle that have to fit together to make a project successful.
So your alternatives presented in the petition and analysis, they don't actually represent all of the possible locations that you eliminated. Is that correct?
They represent viable alternatives until they became not viable. So we did a thorough investigative review of southeastern Massachusetts to get to these 3 sites. But these were the sites that were moved forward to a point to which they were no longer able to be developed because of information that was found out at a given time.
Can we agree, though, that when you start with a broader list, those sites are deemed viable until they're eliminated by a factor, whether it's one of the major ones, the 5 major ones that you list, or another factor?
I would say that they would be deemed options until they're deemed viable, if that makes sense.
And does the term viable appear, where does the term viable come from?
I guess it's a subjective word. If a property appears viable from a development perspective, it could be a successful project until information is found out in one of these major factors or in another realm that essentially makes the project no longer able for a variety of reasons to move forward. So that could be from a transmission perspective, from an environmental perspective, from a land availability perspective. If a parcel of land looked like a reasonable size and adequate size for a project and was adjacent to a substation that where a battery project could add value, but the private landowner was not able to engage in an option contract, that's an example of something that might very quickly become not viable because of that piece of information.
But someone who reviewed the information that's been filed into the EFSB's docket in this proceeding wouldn't have any way of knowing what alternatives were rejected other than the 3 you listed plus the no build. So the 3 actual alternatives plus the no build that you listed in the petition, correct?
Correct. The information we provided was the requirement of the alternatives that were looked at, as well as the preferred site, as well as a no build.
When you say requirement, what requirement are you referring to?
The process that we are in requires a review of alternative sites, which was done here.
Requires a review. Okay. And so okay. But you didn't disclose your review of other alternative sites outside of these 3 sites, the Falmouth, Carver, Wakefield, and of course the no build scenario. Is that correct?
That's correct. We proposed the alternatives that we thoroughly reviewed and developed until a point, which is Falmouth and Wakefield, as well as our preferred site, Cranberry Point.
And you did not provide, in response to information requests, any document concerning any possible site that you looked at other than those 3 and the no build scenario, correct?
That's correct.
So really, Cranberry Point, Save the Pine Barrens has no way of knowing what other alternatives you looked at or the reasons you rejected them, correct?
Again, we provided the alternatives that were in development with Cranberry Point until a point in time which they were not, as these were viable alternatives until they became less optimal options.
Let's turn to what's been marked as Exhibit SPPB 1-59.
I'm there.
So, and you can correct me if I'm misphrasing this. In this question, we asked you what you meant, not you, the company meant by closely abut in terms of determining whether a proposed project would closely abut residences. Is that a fair summary of the question in your mind?
Yes.
And your response is, there is not an exact distance that went into the company's evaluation. Proximity to residences is considered an important factor alongside the other major requirements, and then the response goes on. So if there's not an exact distance, is there an approximate distance?
So distance to sensitive receptors like residences is something that is considered during the siting and development process. And while there's not an exact distance, typically we are considering other factors that would be that would impact those sensitive receptors. So would there be concerns from a noise perspective in terms of being able to meet noise standards, whether at the local or state level? Are there setbacks that are locally imposed that the project would not be able to, that would be an impediment to the site design where that, that closed receptor, it wouldn't make sense to site that close. And so it isn't a defined term as in terms of closely abut, but we look at the factors that I just laid out, as well as understanding, are there considerable or significant aesthetic or viewscape concerns given other land uses approximate or close to the site. So those are ways in which we review sensitive receptors like residences adjacent to a project site that we're developing.
Do you include that level of detail in your petition and analysis concerning just the 3 alternatives that you identified?
We listed the distance to homes in our petition for the alternative sites.
Is it correct that your testimony just said that there's no exact distance?
Correct, but we did list the approximate distance from the alternative sites that we reviewed to residences.
But if there's no
And so
exact,
the other 2 sites, sorry.
yeah, you can finish your answer. That was me.
The other 2 sites did have residences closer to residences that were closer to the project sites that we were currently looking at that time. So that was a factor in thinking through the holistic development approach of understanding if there would be potential concerns from, again, a noise perspective, for instance, or a viewscape perspective. So it's one factor that we consider, yes.
If I look at the petition and analysis as to the 3 alternatives, and I see the distance, am I going to understand the reasons why one distance was deemed sufficient and another was not deemed sufficient under this factor?
I think that might be a subjective, can you rephrase your question?
Well, is this factor subjective? Let's start there.
I think that because battery projects differ from a site design perspective and local codes differ from a noise requirement perspective, for instance, or view shed requirements, I do think there is some subjectivity into what is close and what is not close, if that answers your question.
So your testimony, and I just want to make sure I'm understanding it, correct me if I'm wrong, is that part of the subjectivity is measured based on local requirements. For example, I think you mentioned a little bit ago in your testimony setbacks. Is that correct?
Those factors, potentially subjective isn't the right word. Those factors differ town to town, state to state. So those factors that are unique to each site that is considered are reviewed and considered as part of the analysis of siting and development.
Does the company's consideration of those factors generate documents?
of which factors, to be
Any of them.
specific?
Let's start with any of them, because the company's consideration of any of those factors generate documents that memorialize the exercise of the company's judgment.
Yes, they can.
Okay. Have they with respect to this particular proposed project?
Yes,
Okay. Has Cranberry Point disclosed all of the documents that reflect the company's application of the factors to the 3 proposed alternatives and the no-build scenario that's in the petition and analysis?
we provided documentation that was relevant to the preferred alternative site, or sorry, the preferred site, Cranberry Point, and information about the other 2 sites. If you can specify if you're looking for something in particular, please let me know.
No, I'm just trying to figure out what I have and I don't have. Okay. So just to be clear, the company possesses other documents related to its application of the factors we've been discussing to, is it Wakefield, the Wakefield alternative and the Falmouth alternative, which are the 2 that are not the preferred alternative.
Yes.
All right. Can we turn to what's been marked as STPB 1-60?
Yes.
So the question, and I'm just going to read it. So it starts with, please refer to your analysis in support of your petition, section 7, page 37. Please describe what you mean when you say, quote, maximum service potential to local electric reliability, end quote. Please identify any standards applicable to this statement, regulatory or otherwise. Did I read that correctly?
You did.
Okay. And then the response is, quote, maximum service potential to local electric reliability, end quote, means that the BESS will improve reliability of the system. And that's the end of the response. So when you say, so am I interpreting this correctly, that maximum service potential simply means that the proposed project will improve reliability?
Yes. What we are saying with maximum service potential to electrical liability is that a project that is in a location that can provide maximum reliability to the electrical system is a reason why that would be a preferred or optimal location for a project.
Allison, this is again where we probably should have submitted the 2016 State of Charge report that was developed by the Massachusetts Department of Energy Resources and the Clean Energy Center, because there is a citation in that report that specifically says strategically deployed energy storage can play a valuable role within import constrained zones.
I'm sorry. Sorry. It says strategically deployed energy storage can play what?
A valuable role within import constrained zones such as NEMA, NEMA /Boston, and SEMA, SEMA, parentheses, Southeast Massachusetts /RI, as these regions experience some of the highest energy costs in the region, resulting ultimately in lowered energy costs to ratepayers. As you provided, Councilor Bertram, that would be a regulatorily supplied maximal reliability service of a battery storage system. That is why Southeast Massachusetts is incredibly important to cite in. To go further, Allison Sand has already explained a little bit about the characteristics of the Carver substation and that it is optimal for a large battery such as this because of the number of lines that allow it to charge and discharge, that thus providing optimal service.
Ms. Shaw, did you review this information request when it was received by the company?
I did, and to be honest, I forgot that we probably should have included the 2016 State of Charge report in which the Commonwealth was encouraging storage development in import-constrained areas such as Carver.
Okay.
Polly, I do believe that the state of charge is in the record,
Oh,
in the petition.
I don't
sorry.
have your binder in front of me.
Is it identified in response to this request?
No, it's not.
Did the question specifically ask, please identify any standards applicable to this statement, regulatory or otherwise?
Yes, it did.
So Ms. Shaw, you're telling me that this is a standard applicable to this statement, regulatory or otherwise?
I am not saying that. There is no standard that I can imagine applicable to this. I am reciting a regulatory, a document issued by 2 regulatory agencies that encourages development because of its higher service potential.
Okay, so it's not a standard now. That's your testimony, correct?
I am not saying that this state of charge report is a standard. I am offering it as a document from 2 regulatory agencies that encourages development in this area because of its higher service potential from storage.
Okay. Well, what I'm trying to understand is when the factor says maximum service potential, why we're defining that to simply be to improve reliability of the system. You know, we use the word maximum there. What does the word maximum mean? That factor.
I would say, Mr. Bertram, that in an analysis of sites for a battery system, inevitably locations are compared against the other. And so in all of those aspects and factors, we are looking for the best option. So that is why we stated maximum and why we're saying that if a battery located in a specific area, to all of Polly's points related to the state of charge, focus on the southeastern part of the state. If we could find the optimal location from that perspective, it will improve reliability of the system.
Were there other locations you evaluated that would have improved the reliability of the system?
Yes. And we list information about why the 2 alternatives could not end up moving forward from a development perspective, but a battery at those locations may have added reliability, but not in the way that Cranberry Point would, as we state in the petition.
I want to switch gears for a minute.
Mr. Bertram, if you don't mind for just a moment, I don't mean to interrupt your flow. It's 2:10. If you want to take a break before you switch gears, I suggest that this might be a time to do it, and we could take a 20-minute break and be back for 2:30. How do you feel?
I think that sounds like an excellent idea.
Thank you. Then that's what we'll do. We'll take a 20-minute break and be back here at 2:30 precisely. Thank you.
Thank you.
So which one do you want? Any one of them. They look like. I know, I'm sorry if we weren't in.
All right. Is
Okay.
everybody back? We have the reporter, we have counsel, we have the panel. Okay, we're back on the record.
Is Mr. Kaiser still in hold somewhere?
If Mr. Kaiser is in hold, we can move him back into the panel.
I've
I
moved
have
him.
no idea.
He's
Okay.
there.
Okay.
Okay.
If it's
So we're
helpful-
back on the record. What we'll do is we'll resume the cross-examination of Cranberry Point by Save the Pine Barrens.
Thank you, Mr. Presiding Officer. So I think this is going to get directed to Mr. Quaranta. It's a very brief sort of diversion from where I was going to go and we broke.
So,
Sorry.
Mr. Bertram, I apologize. You're coming across very, very softly. Really hard to hear. I don't know if it's a Zoom setting or.
Okay. It's not too often that I'm accused of being quiet. So is this better?
Sorry, no worries.
No, that's fine. I'm not trying to yell at anybody, but at the same time, technology is not easy sometimes. So if at any point you can't hear me, please let me know. If at any point I'm too loud, please let me know that too.
Thank you. Understood.
Okay. So I just wanted to ask you, make sure I understand. There's been a number of fire tests now on various components of the battery system. So as I understand it, and if I get this wrong, please correct me. There has been cell level test, a unit level test, a module level test, and then we have the Fisher report as well, which is different from those three, or?
The only correction I would make is that the Fisher report is the third-party stamped engineering report that has reviewed TUV Rhineland's unit level test. So those two, you should think of going essentially hand in hand.
Okay. So really, if we're talking about tests, if you will, discrete tests, there's three, the unit, the module, and the cell. Is that correct?
The court reporters.
Just sorry, I had some technical issues. Could you begin that question again? And could I ask you, in your previous question, the first of the three tests that you mentioned, was that L level test? I couldn't hear you.
You will.
Can't remember. Maybe I can withdraw that line of questioning and we can just start afresh. Okay, so I think what I'm trying to ask is, in terms of discrete tests, would you agree with me that there's three? There's a unit level, a module level, and a cell level.
Yes, there are three certification tests done, and those are the three done for UL 9540A specifically.
Okay, all right, that makes sense. In terms of, are those all tests that are required by the standard you just referenced?
I'm sorry, they're all required by what?
The standard that you just referenced.
Yes, and I'll ask Lieutenant Rogers to jump in if I misstate on this, but the way the UL 9548 test is constructed and set up is a step test or a tiered test. So for example, just purely hypothetical, if you took a battery cell and forced it into thermal runaway, and it does go into thermal runaway, you, by the language of the test, fail at a cell level because it did go into thermal runaway, but that's expected. You then go to a module level test. And I have seen some product suppliers, as an example, when they then test at a module level per the criteria in the test standard, have no issues that then would cause them to need to go to unit level test. So technically, they would be complete with the test process at module level because it doesn't heat up, it doesn't go on fire, it doesn't explode, it doesn't do anything. However, my industry experience is that because of the awareness, safety concerns, and protocols that are in place, everybody would want to see that unit level test. And that's why you'll see almost all vendors, at least in my experience, will go all the way through to that unit level test for their product. So does that make sense from a general description of how it works?
Yeah, no, I appreciate that. So we have these three tests, and I guess we can then agree that these are all part of the full-scale fire testing for this proposed project?
They are.
Okay. Can you turn to what's been listed as exhibit STPB 1-1?
Yes.
Let me know when you get.
Okay, sorry, I am there.
In response, little a, if you go about 3 sentences in, it says the results of the full-scale fire testing on the Megapack 2 XL system is attached. Were each of the 3 reports we just discussed attached to this response?
At this point in time, no.
Okay.
All that was submitted was the UL unit level fire test for the product, which is the, I guess my interpretation of what the full scale fire test would be because it was the full system.
I thought we just agreed that the full-scale fire testing included all 3 reports.
Oh, no, I understand I understand your distinction. And I'm responding that at that point in time, the unit level test was what was provided and what we had in possession in September of 2022. I understood that the cell level test and module level test were completed, but we didn't have those documents in possession.
Do you say that in your response?
I guess we didn't deem it necessary at that point. We gave you the UL documentation we had for the system.
So when you, all right, so when you made the statement in EFSB -S-1, which is what we referred to in the question, about what you were relying on for full-scale fire testing, you weren't actually relying on all three reports. Is that correct?
From my experience, the UL 9548 unit level test is the most relevant, important test because it's what is resultant of the entire system. That's where the most information, and again, Lieutenant Rogers, feel free to join in, the most relevant information of how the system is going to function in a failure event on a site, if one was to occur, is that unit level test. That is, sorry.
Yeah, I just want to try to clear things up on this. When UL 9548 test was developed, it's a data collection test, and you're actually getting raw data. A lot of people were concerned that the authority having jurisdiction would not understand the raw data. So what they did is they put it into something that is readable for everyone to understand how to interpret the raw data from each one of those tests.
Have you reviewed Mr. Milosh Pitkovsky's resume in this proceeding, Lieutenant Rogers?
I have.
Are you concerned that he would have trouble understanding those tests?
Not sure.
I would guess he would understand that.
I guess this is to either Lieutenant Rogers or Mr. Quaranta. Mr. Quaranta maybe, because he just testified. You said that you did not, as of the date you submitted this response, possess the other two reports. When did you come into possession of those reports?
I would need to check my email to confirm the exact date, but I believe they were in response to one of the most recent EFSB information requests. That's when I requested the data from the manufacturer.
Well, I understand that they were made in response to the EFSB's requests, but at what point did you actually come into possession of them, if you know?
When I asked for them, so typically those reports aren't shared publicly. They typically get into sensitive, proprietary, commercially sensitive details of how the cell is constructed and cell components. And it was based on the EFSB request that the legal requirement to submit those documents was processed through to the manufacturer, and therefore we received the report. From a industry perspective and an AHJ perspective, what they're going to want to see and understand is this unit level report. And I was looking in the unit level report. I apologize for not being able to cite this, but it does actually on page 17 in Annex A reference and is understood by anyone familiar with the standard that you can't get to unit level test without having done the cell and the module level test. But the relevant data from a system level, project level, is what's in this unit level report. And I believe I'd have to go look at it. The Fisher Engineering report does make reference to the same thing.
All right, let's switch gears again to the zoning exemption request, the application for a zoning exemption. And I don't know who this is directed to, but hopefully somebody will, hopefully I haven't scared everybody and somebody will answer. I believe we've acknowledged at this point, although we could acknowledge again, that the proposed project currently has what in Massachusetts we call a special permit for its construction and operation issued by the town of Carver. Is that correct?
Yes, that's correct.
And it also has what we call a site plan approval. Is that correct as well?
Yes, that's correct.
And so can we agree that at present, it's not going to happen, but hypothetically, if this proceeding ended tomorrow, and you were able to see Mr. Corona laughing.
Sorry,
that's my fault. If you were to pull building permits, there would be no impediment from the town of Carver in proceeding on this project. Is that correct?
If tomorrow we submitted a building permit and received a building permit, then yes, we would move forward. We would be able to move forward with the project, but that is not the reality, as you stated.
Is there any pending proceeding at present before the town of Carver Planning Board to modify either the special permit or the site plan approval?
No.
Is there any proceeding pending before the town of Carver Planning Board to rescind or revoke or otherwise invalidate either the special permit or the site plan approval?
No.
Have you received any correspondence or any other written communication from the town of Carver's planning board about any form of a hearing in the immediate future concerning either the special permit or the site plan approval?
No.
We heard a little testimony the other day about the town of Carver's town meeting. And it sounds like everybody learned that there is a provision in the general laws that allows 10 residents to petition town meeting on pretty much any subject they wish. I believe the testimony yesterday, but I'll allow you to, address it again so that we're starting with a fair start here, was that you didn't have an opportunity to address the town meeting. Is that correct? And if it's not correct, please clarify. I'm not trying to make this a memory test.
My understanding is that in the town and in Massachusetts, a non-citizen or resident of the town that we're talking about here in Carver would need to request permission to speak at an annual town meeting.
Did the company request permission to speak at the town meeting?
No.
Is the company organized pursuant to any kind of franchise that's issued by the state?
Can you clarify your question, Mr. Bertram?
Sure. There's a number of utilities out there, like a natural gas company, for example, may be granted a franchise from the state to operate in a certain area. Is either Plus Power or Cranberry Point Energy Storage System LLC, I want to get the legal name correct, are either of those entities organized pursuant to a franchise issued by the state?
No.
I believe the other day, when asked about being a public service corporation, I think it was Ms. Sand, but I may be misspeaking, said that the company is providing a necessity to the public as a reason why you're a public service corporation. Is my memory accurate, or do you want to clarify that?
I did state that, Mr. Bertram. I will say, though, if we're getting into legal terms, I'm not an attorney, so could not provide much further beyond that.
That's fine. Are there any other reasons that you are aware of, Ms. Sand, that the company, that makes the company believe that it's a public service corporation other than providing a necessity to the residents of the Commonwealth?
I can't provide any more context, given that I'm not an attorney. to the definition of a public service corporation.
So the company has filed with, technically it's the D.P.U, but it's part of this consolidated proceeding with the EFSB. It has filed an application for a zoning exemption, correct?
That's correct.
And that is only for what we call a comprehensive zoning exemption and not individual zoning exemptions. Is that correct?
That's correct.
Are there any specific provisions of Carver's zoning bylaw from which the company is actually seeking an exemption?
As stated yesterday, because of the battery energy storage specific moratorium that's currently in place in the town of Carver, and because we previously received a site plan review and special permit, but have yet to get to a point in the phase of the project where we would be seeking a building permit from the town of Carver, we are moving forward with the comprehensive zoning exemption because of future potential bylaw changes that in the events that have unfolded over the past year, you know, given the makeup of the current planning board and the moratorium are likely to occur with the battery energy storage study committee that's in place currently to review the bylaws and potentially amend or change the bylaws.
When you reference the makeup of the town of Carver's planning board, how many members have changed since the special permit was issued?
I would have to double check on that, Mr. Bertram, but I know that at least half or 4 or 5 have changed, I believe. I would have to check that though.
Okay, so there
It was 3 years ago.
Has the town of Carver's planning board, again, have you received anything from the town of Carver's planning board indicating any form of impending change with respect to the special permit or the site plan approval?
No.
At this point, I would interject that Save the Pine Barrens is quite publicly trying to stop this project, including a press release, the press conference that I heard of today with emails being sent to policymakers asking to stop this project. They are repeatedly posting in social media that this project should be stopped. If the concern is why we're worried about this, it's because there is clearly a lot of activism to try to stop this project by your client.
Mr. Presiding Officer, I don't think that was responsive to my question, but in any event, Ms. Shaw,
Are you moving to strike the answer or?
no, I
moving
think Ms. Shaw could be instructed to keep her answers within the scope of the question. It's running a little late in the day and I don't want to be here all day. I'm sure if it's important, her attorney will redirect. He's an excellent attorney.
That's fine, Ms. Shaw, if you could just keep it within the parameters of the question being asked by counsel, and you will get an opportunity during redirect to address any concerns that are not objected to.
Just give me one moment to see if I have anything else on this. Oh yeah, Mr. Quaranta, I think you testified the other day that you were present for the town of Carver's town meeting.
I was in attendance for a percentage of it. It was quite full. And then immediately after, I think 3 different topics were voted on, most of the people left. And then I was able to sneak in and sit on the stairs.
Were you present for town meetings discussion and vote with respect to the moratorium that you guys have testified to?
I believe I was in the room for the majority of it. I think I missed the very beginning. I don't Don't remember exactly when I was able to walk in.
Did,
It was it was about an hour and a half wait outside waiting to get into the building.
did the town's attorney address town meeting at any point in the discussion on that article?
He addressed it several times and contradicted himself, I guess, from my non-attorney perspective, when he did address the town meeting.
Given that,
I know it's, sorry,
so I was actually going to address the presiding officer rather than make this a memory test for you at this point, Mr. Quaranta. This could be to the company, or frankly, if you want to issue it to me, I can issue one to myself. If we could get, trying to think of how to phrase this. Actually, I'll withdraw this at this point. I'll think about it for later.
That's fine.
I think, Mr. Quaranta, and again, you can correct me if I'm wrong, that yesterday you testified about the special permit as having conditions that you believe the project has to follow. Is that correct?
yes, that's my understanding of the definition of the result of the permit.
If the D.P.U. / EFSB issues a comprehensive zoning exemption, would the company still have to follow the special permit or those conditions?
I can't comment on the legal aspect. I'm actually not sure. I would expect we would still follow the intent of all of those to be, continue to work positively with the town, but I can't comment on the legality of it.
Well, I think this is a fair question for somebody on the panel. The company has filed an application for a comprehensive zoning exemption, and I've heard witnesses testify that they view the special permit as, setting forth conditions that they have to follow. But Ms. Sand, what is your understanding? If you get your comprehensive zoning exemption, does the company still need to follow the special permit?
We have every intent of moving forward with the conditions that were set forth in the site plan review and special permit. But we, given what I stated earlier, are seeking the comprehensive zoning exemption to ensure that there are not impediments to the progress of this project in case the zoning bylaw changes in a way that could prevent the project from moving forward with its current design or with the timeline of the project that we're seeking right now.
So why didn't the company file an application that seeks an exemption only from something to future zoning bylaw changes rather than seeking a comprehensive zoning exemption from the town of Carver's current zoning bylaw?
I can't speak to the legal reasons, given that I'm not an attorney, but this was the path forward that we felt was most appropriate.
Has the company entered into any form of an agreement or a memorandum of understanding or anything similar with the town of Carver that even if a comprehensive zoning exemption is issued, the company still intends to comply with the conditions and terms of the special permit?
We have not entered into such an agreement.
Okay. I have, I'm going to change tack entirely and go back to the emergency response plan. So I think most of these will be directed again to Mr. Quaranta, perhaps Lieutenant Rogers as well.
I'm sorry, can you, and possibly what?
And possibly directed to.
I'm sorry, you're just really soft.
Let me.
To channel your inner me.
Okay, so these questions will be directed mostly to Mr. Quaranta and possibly some to Lieutenant Rogers as well. Can you hear me okay now?
Yeah, very clear. Thank you.
So if you could please open the emergency response plan, which for the record is the attachment to EFSB-S-44.
Well, yes.
Thank you. And actually, if you could also open up EFSB S-38 as well.
Oh, EFSB, sorry, thank you. I have that. Thank you, sorry.
Thank you. So Cranberry Point had originally submitted a draft ERP that was attached to the petition. Is that right?
Yes, that is correct.
And this updated one that we're looking at now was filed on October 20th, right?
Yeah, yes.
Can you tell me why a new draft was submitted?
Yeah, so to update based on the request from the EFSB and provide, additional details to the EFSB, we took the opportunity to update the ERP with the current level of project information. It will not be the last time it is updated through the rest of the project, even in the operational cycle of the project.
Okay. Has this draft been shared with the Carver Fire Department?
It has.
And when was it shared with them?
I will confirm if you'd like as a record request, but I believe it was on the 21st. It was in the same email sent with the HMA.
Okay. So kind of looking more generally, what is the purpose of the ERP?
So the emergency response plan is a document to provide inputs to the first responders on the unique aspects of the project or product so that they have information to understand, along with their existing training and certifications as a certified call fire department in the state of Massachusetts, to support an incident that might occur, whether life safety or fire or other event.
And what is a certified call fire department?
It is a department that meets the regulations in mass.gov and typically requires, and now I'm saying this as a Massachusetts resident who's lived here all my life, not a firefighter myself, so I found it. Usually it means firefighter 1 and 2 certification, at least for all staff that aren't grandfathered, as well as other appropriate trainings per NFPA.
What does the call part of that mean?
It just means that they are not full-time staff that sit at the department every single minute of every day. It means that they respond when a call occurs. And for example, many towns in Massachusetts have that sort of a system that don't have the sort of incident rates to have a full-time staff, as an example. However, in the example of the Carver Fire Department, they are a pretty unique fire department in that regard, given that they're also capable of doing their own certification training at their department. They have designated trainers as part of their staff full-time, and have licensed, burn buildings and other training apparatus that are used not only by them, but other districts in the state.
But the firefighters don't live at the fire station, do they, when they're on shift?
No, they respond from home, and I believe on the website it dictates they have one of the best call times in the state of under 5.5 minutes on their public website.
So now I think I'd just like to kind of go through the emergency response plan and ask you some questions about some things that are in here. So I think we'll start with
Sure.
section 1.1.
What number is it?
Let me-
I've got the version. It's I believe the emergency response plan is part of 37 and 38.
I believe part of
EFSB. I'm sorry, Mr. Bertram. Thank you, but I didn't hear that.
Sorry, this is S44.
Thank you. Sorry, S44.
Glad you didn't hear me. I was wrong.
I will not hold it against you.
I had asked you to get out S38 as well, but we're not going to need that. So you can clear something off your plate anyways. So let me know when you're at section 1.1.
I am scope.
Okay, scope, right. So the second paragraph here states that this document serves to satisfy the emergency operations plan, parentheses, EOP for the Cranberry Point Energy Storage Project in accordance with section 4.3.2.1 of the 2023 edition of NFPA 855. Did I read that correctly?
Yes.
Can you explain what is an EOP?
So I will start and I'll allow Lieutenant Rogers to add to it if I misstate, if that's okay. I think the emergency operations plan and emergency response plan can sometimes be used together or synonymously in different ways. And they can kind of combine the overall aspects of both things. An emergency operations plan, and I think rightly, Mr. Pachowski documented it as well, I think from one of the standards, provides detailed operational activities that one might undertake in dealing with a particular emergency situation. And I don't know if I missed anything, Lieutenant Rogers, am I?
Yeah, it could incorporate a couple of different aspects. Number one, it's got to have information about if there was an event that took place, how can we guide the fire department to considerations on how to handle an event. It also incorporates people that may go to the facility for inspection, testing, or any maintenance. So all of that is included in the whole operations plan. We call it emergency response plan. I think Mr. Pachowski said that an ERP can also double as an emergency response plan, or an emergency response plan can have the elements in it that will cover the sections for an EOP, which is an emergency operations plan.
Okay, thank you. Does an EOP typically include any information or planning concerning, sorry, strike that. Does an EOP or an ERP typically look at, in the event of a sort of larger emergency, what sort of outreach or safeguards are put in place for the local community, people living near the facility, or who might sort of need to get information about such an event?
So I would answer, and again, Lieutenant Rogers, feel free to add, that it can I don't think it has to. And the reason I would cite that is that there are a large host of procedures that I can't attempt to describe that, you know, a fire department such as Carver Fire Department already has in place to deal with hazards or other, you know, issues that occur in general. I mean, I think, for example, the Plymouth Airport is technically the end of the runway is in Carver, Massachusetts. And I know they have procedures to deal with, you know, an aircraft issue or something of that nature. So the intent of the emergency operation plan is not to replace or supplement existing materials and trainings and procedures that the fire department has in place already. It's to provide them with the detail and information on what's unique or special to the site. That all being said, there's no reason it could not cover those same things as well. I think at the point that this would be completed and at least in a finalized state at the conclusion of the project before going into operations, that it's a collaborative effort with the Carver Fire Department as the AHJ and their code enforcement officer to make sure this meets all of their requirements explicitly in whatever way, shape, or form they deem it's most appropriate for them to provide response to the community. Did I miss anything?
Yeah. Was that suffice, or do you want me to add some more?
No, I've got a couple of questions, actually. Is there another 150 megawatt battery energy storage system located in Carver?
I do not believe at this time there is no.
Are you aware of any procedures or policies or any other similar documents that the town of Carver on-call fire department may have that would apply to a 150 megawatt battery energy storage system?
So I know from conversation with the Carver Fire Department that they are already supporting other projects that have a battery storage system installed. And whether it's a 1 megawatt battery energy storage system or a Tesla Powerwall in your home or 150 megawatt battery system, the details of what you're going to do to manage an incident response are still going to be consistent between all of those and be informed by the UL 9548 unit level test.
So if I had a battery storage system in my home, is it your testimony then that there would be no difference in response from a fire department between responding to a fire in my home as there would be to a 150 megawatt battery energy storage system?
I think you need to quantify what you mean by a 150 megawatt battery storage system on fire.
Would there
Do you
be
mean
any
one
difference-
enclosure?
Would there be any difference in, could there be any difference in responding to an incident at a facility such as the one you propose and a battery fire in somebody's home, which you just referenced?
I would actually expect, and I'll let Lieutenant Rogers comment, that in some ways, the battery fire at my neighbor's home where he has a power wall installed in his basement could be much more serious and risky than a fire in an unmanned facility protected by a fenced-in area and spaced appropriately between equipment based on the UL 9548 unit level test results. Yes. Lieutenant Rogers, I don't know.
If I could interject, I'm just trying to make sure we're clear on that testimony before. It sounded like you testified that there would be no difference in protocols or procedures. And I'm just trying to establish a foundation that yes.
Yeah, let me just.
Yeah, I'm sorry, and I'm just
So-
trying to, I'm sorry, wait, and I'm just trying to establish what?
A foundation that there would be. I think that's Lieutenant Rogers' cue now.
Well, let me just clarify on my point. I would quantify, or I would clarify that depending on exactly what the incident is, but from a response perspective, if you have a cell that goes into thermal runaway on a enclosure that's part of a 150 megawatt battery site, and you have a cell that goes, or a hoverboard or something else that goes into thermal runaway at home, the response aspect to that, I would expect to be extremely similar, if not the same. And Mr. Rogers, feel free to.
Do you expect that a home hoverboard would have the same number of battery cells as a Tesla Megapack 2 enclosure?
That's an entirely different question.
Well, for example,
So what I said was, I'm sorry,
no. I think we've plumbed the depths of this and we're getting caught up in a rabbit hole that we don't need to at late in the afternoon. So I'm going to turn this back over to my colleague.
Let's please go to section 2 of the ERP.
sure.
So I'm really just looking at the last sentence of the second paragraph, which says that all facility personnel have a responsibility to immediately report emergency situations to the O&M manager or lead technician. So my first question about that is just, are these personnel anticipated to be on site?
So the site is not expected to be fully manned. The way the document's written is, as a draft, there will be O&M people that are on site. There will be an O&M manager responsible for the project. And the way this is written is, if there are people on site, all facility personnel would have the responsibility to immediately report situations, et cetera. It's written in that intent, but it's not that the site would be fully manned. It's not like there's an operations center or like in a large oil-fired, gas-fired power plant where there's a full-time 24/7 staff.
People might sometimes be on the site though, is that right?
Yes.
For maintenance?
Yes.
Any other reason?
Typically, it would be maintenance, maybe general inspection. There are preventive maintenance procedures for all of the equipment, including the substation equipment. Fairly routine processes and procedures that you would go through to manage a site like this.
Okay, the O&M manager, just to be clear, that's the operations and maintenance manager, right?
Yes, it would be the lead person for the site, yes.
So what qualifications would that person, well, sorry, strike that. Has the O&M manager been selected yet?
They have not.
So what qualifications will that person need to have?
So I'm going to speak, we have an organization that would support this within the company, but from my experience, they would typically be familiar with substation level equipment, would have familiarity with electrical installations, with a battery-based system would be advantageous, but not necessarily completely required from this particular role. It's something that they would be able to understand and learn, manage, from their perspective and their role in terms of managing the site as a overall energy facility. That's in general the sort of things. Obviously, good project management skills, would likely be trained in OSHA 30, would have first responder in terms of like basic AED, first aid certifications. They're not an EMT or a firefighter. They're a manager of a facility that's an energy plant.
Just one moment, please. Okey-doke, thank you.
So would there be any person charged with day-to-day oversight of the facility that did have expertise in BESS?
Yes, at a couple of layers. So there would be operations and maintenance personnel that would be remote or offsite that would monitor the system operation, health of the system, any alerts, alarms, warnings, anything that particularly happens. Unlike a large rotational machine-based sort of power plant, there's not a lot of things that would need, daily on-site care or maintenance or that sort of thing that you might see in a traditional power plant sort of environment. So there's not really a need to have someone that's there on site all day, every day, looking at a bunch of cabinets, so to speak. But there would be trained staff that would be monitoring the system. There would be resources within the company that also would support those resources. And there would also be the equipment provider, Tesla. So as part of our normal course of business with a company such as Tesla, there are agreements that are put in place to support the system from a product perspective. And there would be occasional personnel from their side on site if a fan failed and needed to be replaced or something of that nature, as an example.
Okay. I'd next like to direct your attention to section 3.
Yes.
So this section 3.1 lists several built measures, and these are passive features, manual firefighting equipment, and fixed fire protection systems. And for each of these, the ERP says they shall be documented during post-construction walkthrough. So my question is, how and when will the need for each of these features be determined?
Sure. And again, I'll refer to Lieutenant Rogers to add anything I might miss, but my interpretation of this is that these are typical headings you would have in the template or draft of the ERP. And as you go through the rest of the design process on the electrical and civil engineering aspects of the project, there will be equipment that will become more detailed and finalized. And those sections, for example, in terms of fixed fire protection system. So if I can use that as an example, there will be a fire detection system that will be installed that will trigger to a fire panel that will then trigger to the appropriate responses, but that detail has not been electrically designed yet. So that's why this particular section does not have material documented in it, but it would be updated as those electrical designs, for example, are specified, exact products are selected, et cetera.
Okay, thank you.
Lieutenant Rogers, did I miss anything? That was right. Okay, sorry.
So next, let's look at section 3.2, which references the Network Operations Center, or NOC. So I have some questions about the NOC. If you could start by explaining what the NOC is and where it will be located, I would appreciate it.
Sure. So I'll start off with the term tends to be used in some levels of generality, and I want to try and hopefully clarify how we see this and expect it to be implemented from the project. There will be a network operating center. I expect that would be through a third party. And I think in one of our information requests, replies, we referenced Nova Source as Power Systems as one of those, who are certified control centers, so to speak, for power plant type operations. IHI Power is another really big example of a company that provides the certified sort of operators that monitor a system 24/7 in a control room setting. And there's a whole bunch of NERC and FERC level certifications that govern those sort of roles, which is why it's usually outsourced to an expert party to provide those services. And that would be the first sort of level of identification of anything happening. So if I can create the visual, it's literally someone sitting in front of a terminal watching status on the system, and the instant anything might occur, they would have an operating procedure that would dictate them how to respond and how to carry forward the appropriate steps to react to that particular situation. So for example, and you can stop me if I'm going into too much detail, if a circuit breaker opened, they would immediately see that the plant lost electrical connection. They would have a call tree that would allow them to notify the appropriate points of contact. One of those would likely be a high voltage electrician that would respond to site to be able to look and see if there was anything really damaged, or if it was a nuisance trip. There would be support staff to look at, meter data and other recorded information to see what had occurred, and then be able to respond accordingly to the incident, as an example.
Okay, thank you. I think I actually just have one more sort of line of questioning on this ERP. So the ERP mentions the risk of reignition, and that's in section 3.4 if you need a reference. But my question is, so the ERP says that even if a lithium ion battery fire has been extinguished, there's still a risk of reignition. How long would that reignition hazard exist?
It's a variable that can be a little bit difficult to document based on exactly what the failure mechanism might be. If we look at the UL 9548 unit level test report, or even the cell level test report, you can see in those documents how they look at temperature of the cell, temperature of the equipment, external temperatures, and then internal temperatures through the system information interfaces to monitor and look at what is happening from a real-time perspective. And the intent of the document is to make sure firefighters or first responders do understand that you're dealing with high voltage electrical equipment first and foremost. They're dealing with batteries, which, as we all know, even from the batteries in our phones and everything else, don't necessarily turn off. And what the intent of this is to inform them is to be very clear that they should not, maybe the same way they would go into a house where they saw smoke, rip the door off, go in, charge in, find where the fire might be and respond to it. We don't want them doing those sort of things. And this is just one piece of data highlighting that risk occurs, and that they want to work with the subject matter expert product, namely the company's subject matter expert and the manufacturer's subject matter expert, on how to appropriately deal with it so they're not at risk of the stranded energy.
Will the Carver Fire Department be able to reach both of those subject matter experts directly?
Yes, if I use experience, well, let me restate that. If I use my experience in projects I've done in my past, the typical detail is that someone would be available by phone to the incident commander within a very short fixed amount of time. There would be a determination that if the event required it, someone would be on site by another fixed amount of time. And it would typically kind of scale from there based on whatever the incident is. That's a fairly typical approach in any sort of, electrical power sort of project or facility. Did I miss anything?
No,
Lieutenant?
that is exactly right.
We're almost done. At least with my portion, obviously the hearing is not almost done. You guys,
You keep reminding us of that, thank you.
the Carver Fire Department, how many fire engines does it have?
Off the top of my head, I don't know that I recall. I think I submitted like literally the apparatus web page off of the. I'd have to look up which one it was though.
No, I'm from, I've Googled it too. I'm pretty sure we're talking about the same thing there. Yeah.
Yep.
Okay. Can we turn quickly to STPB 1-35?
Yes. It's 35.
Yes, we have that ready.
Sorry.
And I'm looking at response little c. This response basically describes within a half-mile radius of the project that there are 535 private properties, all of which are assumed to be served by private wells. There are also 7 public water supplies. Would you agree then that within that half-mile radius, there are a number of water supplies that service residents of Carver, businesses of Carver, and potentially others?
Yes, I would.
Is the town of Carver located on a sole source aquifer?
Yes, it is.
I'm sorry, who is answering?
Tom
Thank
Keough.
you. Thank you.
So if we could now turn actually to the next response in sequence, STPB 1-36. I'm not sure if it would be in the same binders if the respondent was counsel.
I'm sorry, I can't hear you, Mr. Bertram. I'm not sure what.
If the response will be in the same binder because the respondent is counsel.
Yeah. That's you.
Yes, I do not have that.
Yeah. My next question, since it's an objection, will be addressed to the presiding officer anyway. And so, Mr. Presiding Officer, if you have that in front of you, there's an objection, but then the answer for each of the 4 sub points is the company has no independent knowledge to respond to this question. I would suggest that doesn't read to me as a legal objection, but simply a statement of fact. And for the record, I would actually like somebody from the company to offer that fact so that I can cite to it as a matter of fact in this proceeding.
Wait, I'll hear from counsel from Cranberry Point.
I'm just reviewing the response.
Yeah, you have it. Sorry.
I don't know what it is. Okay. Let me just give it to Mr. Keough.
Okay.
So you can see. He's going to ask you if you have documents for each of these things. You don't, so which is why we object. Yes, I have it in front of me now, Mr. Bertram.
Attorney Kaplan, is there any problem with the objection being overruled or sustained?
No. I have no problem with Mr. Bertram asking Mr. Keough questions on that information.
Thank you. Thank you, Mr. Bertram.
Thank you. So it's STPB 1-36. I guess I would just ask Mr. Keough, now that the objection has been lifted, if he agrees and with respect to each of the 4 subpoints, A, B, C, and D, that the response, the company has no independent knowledge to respond to this question, is actually accurate as a matter of fact.
Right, correct. I mean, for the volumes of water that may be used in response, it's my understanding that water would not be used. So I don't know how to answer that. I don't have any independent information for that. I'm unaware of where the Carver Fire Department currently gets its water from. I do not know the apparatus that the fire department would use in order, if they were to go against, the advice of Cranberry Point and what would be contained in the safety plans and actually use water at the site. And I do not know what resources Carver has on hand or the infrastructure. And once again, because it comes into a use of a certain volume of water, and it's been explained to me that there is to be no use of water on the site in the event of a thermal runaway.
Okay. Thank you for that answer. I'm just going to put the question to the rest of the panel too, because I think some of the questions that were asked here, speak to the Carver Fire Department, and I know that certain other members of the panel have talked with them. And I just want to make sure that as a response for the company, and that not just based on Mr. Keogh's knowledge, that we have all of the relevant details. So if does anybody else on the panel have anything to add to that, or do we all agree that the company has no independent knowledge to respond to this question, as supplemented by Mr. Keogh? I'm sorry, I'm sure I'm pronouncing your name wrong. Is correct?
That's correct. That's correct. Thank you.
Yeah, and I think if I can describe sort of the intent of the response, the same as you pointed out, I could log on to the Carver website. I could read the information about what vehicles they have. I could apply my own personal thoughts and considerations, but I'm not a trained firefighter. I'm not part of the Carver Fire Department. So for us to give you data that reflects how they would act or respond in a, official legal response, that's why we had the response to the question we did, along with what Mr. Keogh already described, in that for a thermal runaway event on an enclosure, the very clear recommendation and supported data from both the UL 9548 unit level test report.
I'm sorry, and supported data from both the what? UL. Oh, thank you.
9540A.
Thank you.
We need a code word for that. And the Fisher engineering report both would support the assertion of not using water on an enclosure that had a thermal runaway event. So that's where the answer came from, Mr. Bertram.
So I understand that the company has been in communication with the town of Carver Fire Department. So given that answer, is it then accurate to say that you have not had discussions with the town of Carver's fire department about the volumes of water or the equipment or mechanisms for delivering that water to the project in the event of emergency responses?
Not to that sort of context, no. I mean, we've likely talked at times. I mean, I had a tour of the fire department. I've seen what the fire trucks look like, but to be able to say exactly how they would operate their vehicles, to at what volumes of water they might use, isn't something we could dictate. Have we talked to them about not using water? Absolutely. I mean, that's a key component of just talking about the product itself and how they would approach the situation. And at least in those conversations, they've been very comfortable with that sort of an approach.
So just to clarify, it's been the content of your discussions with the town of Carver's fire department is that they should not use water in responding to an emergency event at this proposed facility. Is that accurate or not?
They should not use water on an enclosure that is having a thermal runaway event. And I think in even the emergency response plan, in that we have that other additional comment where it says, unless the incident commander deems that there is an external reason necessary to do so, then always you would defer to that appropriate person to make a decision. The point is that it's not necessary to dump water on a enclosure that has a thermal runaway event. It is not needed and necessary.
But it's possible that water could be used in response to an emergency event at the proposed facility.
There is a possibility of water being used on a brush fire near the facility or a piece of electrical equipment that has an electrical short circuit and they deem necessary. Sure.
Is it possible that water could be used in response to an emergency event at the facility that includes a thermal runaway event on an enclosure, but perhaps it's not
I'm sorry, that includes a thermal runaway event.
at an enclosure, but it's potentially not limited to that?
I cannot answer conclusively to say that someone wouldn't decide at some point in time to put water on an enclosure that was experiencing a thermal runaway event. I would just note that based on the data that we've supplied, if they applied that water to an enclosure that was having a thermal runaway event as dictated in the UL 9540A report, they would be putting water on a non-burning, non-open, non-exposed piece of steel equipment that I think would be generally treated as rainwater and not as anything else.
Can I just chime in? I just want to make sure we're still on 1-36 and I haven't lost track of where we're going. Because if somebody puts water on, are you asking what the volumes of that water would be used? How many volumes of water would be used in the event that a firefighter did put water on a container or an enclosure? And the source of the water? And the mechanism to deliver the water, whether it's a fire engine or a hydrant, and whether the town would require additional equipment to do that? Is that what you're asking?
Well, I haven't asked any of those things yet.
Well, actually, that's the question that is in 1-36, and that's what I'm asking. Are you still on 1-36?
I think I've moved beyond 1-36 at this point.
Thank you.
Sorry, if you wouldn't mind, Ms. Bertram, restating, I'll try and make sure I'm answering correctly.
Well, I was actually about to move us to somewhere in the ERP anyway, so maybe that will help to reground us in the documents that we've been discussing. So if we can,
Sure.
if I remember correctly, that was EFSB-S-44.
Okay.
And I am looking at section 7, which I believe is page 33 of 84 in that document.
You said 33 or 37? I'm sorry. 33, okay.
Which one?
Page 33 of EFSB S-44. Yes.
Okay, thanks.
You there?
33.
Just let me know when the panel is ready.
Oh, I'm sorry. I'm good. Yeah, go ahead. Sorry.
It's late in the day, I get it. So if we look at 7.1, the first sentence, the general approach for this application is to apply water to adjacent exposures if necessary in a defensive manner rather than aggressively attacking the fire in the burning unit.
I'm sorry, the fire in the what?
In the burning unit. Does this say that if you apply, does this say that a defensive approach is to apply water, perhaps not to the enclosure, but to other adjacent exposures?
Yes,
Yeah, I can answer that.
Sure.
Because this is going to come down to training in the fire department. Water is basically a double-edged sword. First of all, you're not going to be able to get it into the container. So it's, as Mr. Quaranta said, it's kind of like a rain coming down on it. We're also going to base that decision on information coming from the BMS, which we are going to speak to the fire department on how to interpret that information. If we go back to the UL 9548 testing and we see that there was no spread of any type of heat except for that one cell, we are going to try to tell them, we're going to recommend the water be limited use if used at all. And we would look at data coming in from the BMS to see if we needed to apply any water. But the testing kind of verifies and validates that we will not see spread of any type of fire or heat inside the enclosure itself.
And I understand and appreciate that, but can we agree that, you know, emergency response planning oftentimes is planning for unanticipated or unexpected events?
sure. Yes.
All right. So if we go back to the sentence I just read, where it says, if necessary, is it possible that it could be necessary to apply water in the manner that this draft ERP specifies?
Yes, to adjacent enclosures. Yes.
Okay. And it's possible that that would be a justified decision based on the emergency event as it presents to the incident commander at the time he's there. Can we agree with that? Agree to that too?
I'm going to tell you that the incident commander and the fire service is going to be able to get data which will give them a more informed fireground operation, which will find out whether the adjacent enclosure is heating up and they need to apply water. Right now in the testing that was done, that did not occur. During that testing with the Fisher report, we did not see any type of heat going to adjacent enclosures.
And we've gone over the reports in this hearing, but my question is it possible that it would be a justified decision based on the information that's presented to the incident commander that he would apply water in the defensive fashion that is specified in this draft ERP?
It is possible, yes.
And so as I hear the testimony today, well, let me go back to Mr. Keogh. Is that what you understood with respect to water and its potential use at an emergency event?
Yes, I understood that it was preferable not to be used at all on the site. And that was the plan in case of a thermal runaway event.
But you acknowledge too that it's possible that water could be used.
It's possible, yes. I would not be in charge of those decisions at the time of an incident at the site. So it's possible that whoever is in charge could make that decision.
And, oh, sorry, can I add?
Yeah, at your panel, I think you can.
Sorry. So what I would add to it is when we did look at this, and again, that's not how we took the intent of the question. We took the intent in terms of, pouring water on that enclosure, but even in the case of surrounding enclosures, trying to figure out how much water and everything else was applied still is not something I practically know. I functionally know how to do from an engineering perspective at this point in time. And that's part why that answer is such as it is. However, we have discussed that in the case that the fire department applied water to adjacent enclosures, that would be no different than essentially stormwater from a rainstorm on site because it's not making any contact to burning equipment or damaged equipment. It's, you know, water hitting the outside of the enclosure. And obviously this is your area of expertise, so.
And so as you had said, there's the possibility that somebody could use water on site, but the IR was, where would they get that water? It's, you know, the Carver Fire Department determines where they get that water. What apparatus they use on site, the Carver Fire Department determines all of that. So on and so forth for the others.
So, but you haven't asked them that, correct?
I do not know about the other project team, but no, I have not been involved in the fire suppression or, you know, emergency response planning.
Yeah, you're correct. We did not go to Flat Carver with this question and ask them to answer it. You are correct.
Well, I think more generally, have you discussed with the town of Carver how, if they decided to use water for defensive purposes, that would be delivered to the site, or what the response scenario would be if that were to happen?
So I can only tell you an answer based on my own experience living in a town that has a volunteer or called, excuse me, fire department, and how they normally do that sort of thing. I can't speak for Carver. I could ask them if you would like, but it is normal practice in many of the small towns in Massachusetts. And again, Lieutenant, you can talk about this, where you don't have a public water supply system, which again is consistent in many small towns in Massachusetts, that you will draft water from a water source, whether a bog, a pond, a lake, or an adjacent town that has water if you need it. And you will use a system of drafting and tanker shuttles through mutual aid to provide whatever water is needed for whatever event. And that's a fairly normal, consistent practice in many of the towns within the state of Massachusetts.
But you're not aware of any analysis of that at the present time?
I am not, no.
And you're not aware of any analysis of the volume of water that might be used in response to an emergency incident if water were used?
Yeah, I don't know how I would honestly guess.
Yeah, that would depend on the failure, right? Whether the incident commander may need water or not, and will all depend on that information.
I don't know. Do you have an example of how much water? Sorry. Okay.
And we don't have any analysis of, I know you said it's treated as stormwater, but if that water hit an enclosure or anything else that was experiencing a fire event or an explosion event at this facility, what the impacts would be to the groundwater or to the aquifer. Is that correct?
I don't. Okay.
Well, first is it's been stated here numerous times in the studies that there wouldn't be a fire event for one of the enclosures.
Is that the company's position?
If water
Fire event at these enclosures?
I'm sorry, I didn't hear the question. There was overlap.
I said, is that the company's official position, that there cannot be a fire in one of these enclosures?
What we're saying is, based on the report from the UL 9548 unit level test, we would not expect it. I certainly am not saying there's absolutely no situation that might not result in that. What? And then go ahead, continue. Sorry.
So if fire was to be used, or if for some reason a fire was to occur and water was to be used, the water would begin to infiltrate, saturate the top layer of the gravel, and then begin to run off and be collected within our stormwater system and contained within our basins.
You can give me that professional opinion, not knowing the volume of water that might be used?
Well, the basins are designed for the 100-year storm. So water on the ground is water on the ground. And it would begin to infiltrate at a specific rate, and it would begin to run off at a specific rate. And those are very general terms, but.
Haven't done an analysis of it.
We have not. we have not been presented with a volume of water that, and no one has proposed to use water on the site. What's the volume of water?
Mr. Presiding Officer, if I could get 5 minutes, I think I've concluded our line of questioning. I'd just like to confer briefly and take a moment.
That's fine. It's by my clock, 3:52. I'll give you a little bit more than 5 minutes. We'll come back at 4 o'clock on the dot. So that'll give you a little bit more time, about 8 minutes. So we'll see everybody at 4 o'clock. All right, let's see who's back. Okay. Looks like we have almost everyone back. We do have a couple of matters to address. We can get started. We're back on the record. Mr. Bertram, have you concluded with your questioning?
Yes, I have, Mr. Presiding Officer. Thank you.
Thank you. Prior to moving on to staff follow-up, if there are any further questions from the staff, I'd like to address the objection that you made earlier this morning regarding Mr. Kaiser's testimony. Would you restate the objection?
Yes, the objection at the time was that the witness was not disclosed in advance as a witness, had not filed pre-filed testimony. In fact, he got to provide quite a bit of direct live testimony for which we didn't have time to prepare. I don't even have his resume. And it was based on a report that was disclosed a week ago. I'd asked at the time that you take no action on the objection. In terms of withdrawing it or a remedy, I would actually ask that we put this over until next week. I would like time to confer with my client and potentially with some outside resources to see what, if anything, we care to do based on that objection, including for potentially getting a rebuttal witness or anything else. But, I simply haven't had time to really take any of those actions yet. And I don't want to unnecessarily make a request if I don't have sort of an understanding or basis for what I think is an appropriate remedy.
Right. I'll hear from counsel from Cranberry point on the objection.
He wasn't wrong. That's okay with us.
So
I'm sorry, I didn't hear what Mr. Kaplan said.
I said that is okay with the company.
Okay, Mr. Kaiser, I did ask you earlier if you were available on Monday.
Yes,
And are you available on Monday?
I am indeed.
Okay, so perhaps we can schedule Mr. Kaiser for first thing Monday morning at 10 o'clock. So that we can proceed through the rest of Monday on schedule. Is that agreed on by the parties?
Yes.
Like I said, I don't know exactly what our request, if anything, will be in response.
I'm sorry, Mr. Bertram, I just can't hear you. Like I said.
Sorry, I sound like I'm yelling at everybody, but if I'm not, he can't hear me.
No.
No, I just wanted to make clear that I'm perfectly comfortable with having Mr. Kaiser on Monday. But obviously I may have a further ask based on my objection. I simply don't know what it might be at this point.
Okay, well, what we'll do is we'll keep the objection under advisement for now. We'll reschedule Mr. Kaiser for again on Monday, and then we'll resolve it if you haven't come to a conclusion by Monday.
All right, thank you.
Okay. Yep. With that, I'll move to staff questions. If staff have any follow-up questions, please let me know now.
I don't have any, Mr. Jabot.
I have maybe one question for Mr. Kaiser, follow-up from earlier discussion, if I may. Okay. Mr. Kaiser, we talked about possible mitigation of sound emanating from the battery facility. And I think you had indicated that that's a very difficult proposition. Sound walls and things of that sort, I think you referenced, among other things.
Yes.
And I think you also touched on curtailment of operations as another means of trying to avoid sound in certain hours. With regard to sound walls, normally we think about these as being large structures that surround an entire facility, but is there another type of sound enclosure that we could consider for a project like this around each of the transformers that are associated with the containers, the enclosures rather?
Yeah, so well, the electrical pad next to next to each of the enclosures isn't as significant as the actual fan noise that's at the top of the enclosure. So to account for that, it really depends on the arrangement of the fans and the flow of air. So if you have, from some photos I've seen of the Megapack, I've seen them in various orientation, but the most recent one I've seen, it exhausts kind of out of the side of the top, or maybe the inlet is off the side of the top. There are scenarios where you could put on more specific barriers, maybe increase the side panel height to go above the height of where those fans are operating. But then you get into certain aerodynamic issues with the actual function of those fans and where it's pulling air from. So there would be a lot of coordination with like the Tesla engineers and the folks who deal with the heat dissipation in those units to develop them.
I'm sorry, who deal with the what?
The deal with the heat dissipation.
Thank you.
Yeah. And that might not be a technical term, but for the transformers, the issue with the transformers is they're relatively tall, all things considered, and generally you want to block the line of sight to the entirety of a transformer, because the sound from the transformer is a combination of the actual body of the transformer and also the cooling fans that may be associated with it. From what I've seen in research, close-in barriers around transformers aren't great at blocking the sound when they're measured in real life, and that's just off of some select case studies I've seen. But realistically, the best for actual transformer noise reduction, looking at stipulating maximum sound level ratings of transformers is usually the easier route to go than putting in something large and trying to solve for it. But yeah, I looked at with the actual BESS modules, I looked at kind of individual barrier type situations that are tighter in, but those weren't performing as well as kind of a larger global barrier around the site boundary itself.
Well, and there may be perhaps a more selective approach if we have certain areas that are getting close to the 10 dB limits. Perhaps certain transformers or certain fans are more problematic than others because it is a 6-acre site, right?
Mm-hmm.
So could we target or consider targeting where sound walls or enclosures or some type of baffling might actually make a difference for the receptors of concern?
That is the standard approach when we're looking at these mitigation options, is we look at the component contributions at the receiver point for each of the noise sources. And we say, okay, this specific BESS unit is creating the greatest contribution. Okay, let's solve for that. Okay, kind of like a leaky boat analogy. Okay, now the next one down the road is the one that's contributing. And so that's the way that we design these types of barriers, is to account for those greatest offenders and kind of continue on from there until we see a measurable reduction toward our goal.
Yeah, so the fans, that's factory built equipment from Tesla, isn't it? Into the the fans that are part of the enclosures?
Yes, I believe so.
Does Tesla, from your knowledge, or anyone else on the panel, offer options to, upgrade or customize their equipment for different installation situations?
From my experience working, oh, sorry, go ahead, Chris.
No, I'm going with it. I have no idea, so I think you might have a better answer.
I was gonna say, basically, no. Tesla is not normally receptive whatsoever to customizing their product.
So there's no sound dampening option that you can place with a purchase order?
They would recommend that the sort of mitigation you're talking about be done at a site level, because otherwise you're going to affect the thermal performance of their equipment.
Right. And would that affect the warranty or the efficiency or any other?
Sorry, go ahead.
No, go ahead. You go.
It would affect warranty, and it would basically come down to they won't do it. And if I touch their equipment and modify their equipment, I've just voided everything whatsoever, everything I have with them from a warranty service perspective.
I am still interested in exploring this a little further. I hear the caution and the sort of reservations about trying to mitigate these sounds beyond what you've already measured modeled. But I think the siting board typically likes to have options to at least consider the possibility of mitigating impacts. And given that we're somewhat still, close to the DEP levels, at least at the property line, I really would like to see the company put forward an option that the board could at least consider and evaluate in terms of reducing the dB level at the closest, or at the most impacted receptors to provide a little margin of safety. And if we could also learn what the practical implications are, cost, timing, effect on warranties or Tesla's requirements. But I rather than just leaving it conceptual, I think we'd really like to get more specific indications of what it would take to reduce noise.
One thing that I would probably put before that might be to look into whether or not other projects who have met or come close to exceeding the Mass DEP limit have actually resulted in community complaints regarding noise. There could be this, to me personally, as a advocate for noise control generally, I see Mass DEP's limit to be relatively conservative. So it may be a scenario where if we're meeting Mass DEP's just barely compliant with it, that might lead to absolutely no issues with respect to people being disrupted or annoyed by the noise that's being generated. So I think that could be a worthwhile endeavor to research into whether or not even being on that cusp of non-compliance, if that is actually an issue historically with other projects.
It's a valid point, but we don't really have other projects of this scale, certainly within Massachusetts, to evaluate in terms of reactions from residents in the area. Probably the largest battery project in service right now is not even 50 megawatts. And that's at a landfill in Nantucket, I believe. So, we have a fairly limited set of storage facilities to look at. I will point out, though, Mr. Kaiser, that, we do have some experience along this line with land-based wind turbines, which didn't require DEP air permits, so they weren't evaluated up front. And we have a number of those installations in different communities, particularly in the southeast part of the state, down the Cape, where the noise impacts as measured after construction were at or close to the DEP threshold and produced enough irritation that several of these wind turbines have been decommissioned at great cost to the towns. So there is some history with regard to how residents react to noise near that threshold, and it is not always a good experience.
Understood. I appreciate that context.
So that brings me back to my question, and I realize, we want to get started earlier on things that require study or engineering, and that's why I'm bringing this up now rather than waiting, which is to see if the company can at least put forward a mitigation option if we are trying to achieve some safety margin below the 10 dB level that gives us a little bit more confidence that noise from this project would not be disturbing to the residents, and would certainly be compliant with DEP's policy. So I think, we don't want to be overly particular and trying to engineer a mitigation measure, but we'd like to at least get an option from the company that at least maps out what could be done and what the pros and cons are of it, including cost, impacts, feasibility, and again, how it affects the warranties and other characteristics that Tesla cares about. So I think that would be a record request. We could leave that till Monday if you want to, help us formulate that in a more useful fashion, but that's kind of where I'm going.
So, Mr. Green, I'm happy to wait till Monday and try to speak with the company and figure out a way to do that. My concern about a record request is that it would be due in about 5 days after you make the record request. And I honestly don't know how long it takes to put together a mitigation plan that you're contemplating. So can I look into that and we can talk about that on Monday?
I think that would be fine, and I'm sure Mr. Jabot will be most reasonable about giving you adequate time to answer the question.
That's fine.
I'm sure
Why
it
don't
would,
we?
but
Well, since Mr. Kaiser will be back on Monday, we can sort of table the record request until Monday. And then I'll have Director Green restate the record request, and then by then maybe you'll have an answer for how long it will take. And I can give
We
you
will.
the extension.
I say we will. I'm not the one actually doing anything. So
That's fine. I understand. I want to make sure that, before we commit you to anything, that you have an idea of how long it will take to provide it. So,
yes, I appreciate that. Thank you.
Director Green, is that satisfactory to you?
That's great.
Great.
So I am done with questions.
Okay. Any other staff have any questions for the panel? Okay, seeing that none do, we are moving on to redirect. So, Mr. Kaplan, do you have questions for the panel in redirect?
So we do, and I was wondering if it would be okay if we took about 10 minutes so that I can just get the questions in my head.
That's fine. It's going to be, it's 4:20 now. We'll be back here at 4:30. And keep in mind also that at 5 o'clock, we do have some staff that will be leaving. So we're going to try and wrap up at 5.
Absolutely. We would like to do that as well. Thank you.
Great. We'll see you in 10 minutes.
I'd be insulted that nobody's showing up for redirect.
They come in. We still have another minute. Okay, let's take a look here. So we have council. We have the panel. We're missing Polly. Ms. Shaw.
I see her.
I see her picture. I don't know if she's with us.
Oh.
She's connected.
Well, between COVID and falling and dislocating her elbow, I'm shocked she's still with us.
There's so much HIPAA violation going on.
TMI.
That's what I was thinking.
I just texted her.
All right. Okay.
Okay.
She's back. So I think we have everyone. All right. Back on the record. We're beginning redirect of the company witnesses. So Mr. Kaplan, the floor is yours.
Thank you, Mr. Presiding Officer. The company just has a few questions for redirect, and Mr. Connolly is going to take the lead.
As long as Mr. Brock doesn't yell at me the way he used to. Ms. Sands, first question to you. You were asked questions about conditions imposed by the Carver Planning Board. Do you recall those questions?
Yes, I do.
Is it the company's intention to comply with all of the conditions of the planning board that were issued at the time the permit was originally issued?
Yes, if our petitions, the 69J and a quarter and 40A are approved by the EFSB, we agree that we would comply with the conditions set forth in our site plan review and special permit from the town of Carver.
Thank you, Ms. Sands.
Thank you.
This is to, with regard to water, and if the fire department were to use water on the site, well, let me ask you, what percentage of the town of Carver is served by public water?
I don't have an exact percentage, but it's the North Carver Water District, I think roughly from the area of Route 44 north.
What does the Carver Fire Department do in the event that there is no public water supply available and they have to extinguish a fire?
My expectation would be that they would draft water from a freshwater source such as a pond, river, or stream.
Do you expect that they would do the same thing if they, against recommendations, had to use water at the facility?
I would expect they would do the same.
If they used water at the facility, Mr. Keogh, what would happen to the water?
If they were to use water at the facility, it would be treated in the same way that a large rain event would occur. The water would begin to infiltrate on the site, and then there would be runoff that would be contained by our stormwater management system and eventually be dispersed to the stormwater basins.
How many gallons of water could that the storm basins hold?
The larger basin could hold 95,459 gallons of water, and the smaller basin could hold 60,906 gallons.
First, looking at the last page of the Fisher report, which is in STPB 1, I believe it is.
1-1.
1-1.
Yes.
Is this a comparison of the Megapack 1 and the Megapack 2?
Yes.
Systems?
Sorry. Yes, Appendix 2 is a comparison of the Megapack 1 versus the Megapack 2/2XL products from Tesla.
And would you describe the differences with regard to the 9540 unit test level?
Yes, so from a UL 9548 unit level test results on the Megapack 1, I'll go back and forth if that's okay. The cells were in the internally heated cells, led to a cascading thermal runaway of all cells on the Megapack 1. On the Megapack 2 and 2XL, when the cells were heated internally, it led to thermal runaway of one additional cell. On the Megapack 1, fire propagation consumed the entire cabinet. On the Megapack 2, there was no fire propagation and no evidence of sustained flaming. On the Megapack 1, flames were observed outside of the cabinet exiting via the thermal roof. On the Megapack 2, no flames were observed outside of the cabinet. On the Megapack 1, heat fluxes recorded at distances of up to 20 to 30 feet from the cabinet. On the Megapack 2, no heat fluxes were recorded at distances of up to 20 to 30 feet from the cabinet. And then the remaining items are consistent across both products. Would you like me to read those as well, or?
No, I don't think on the same. Those are major differences between the two megapacks.
From a UL 9540A test, unit level test, yes.
Okay. This is for you and Mr. Rogers. You were asked a question, or not allowed to ask a question, with regard to fire in a home caused by a power pack, Tesla power pack, or a hoverboard, or some other battery operated device. What's the difference between a fire at the facility and a fire caused by a megapack, by a power pack, or a hoverboard, or something else in a home?
So my response to that, I'll go to Mr. Rogers after that, Lieutenant Rogers after that, is that if a lithium-ion battery fire were to occur in the home inside an enclosed space that is a livable, habitable space, that the risks due to that fire event would be significant in comparison to if a cell went in a thermal runaway in a unmanned, non-accessible enclosure in a power energy facility, that would not have the same life safety risks as it would the example in the home. And I'll defer to Lieutenant Rogers.
Yeah, it all comes down to down to life safety in the scenario that you said right there. In a home, a dwelling where someone is sleeping or residing is a much bigger event as far as life safety is concerned. That's paramount.
Is the Carver Fire Department training for such an event?
I'm sorry.
I'm sorry. I just couldn't hear the end of you, Mr. Rogers. In a home, a dwelling where someone is sleeping or residing is a much what?
Is paramount.
Last question. Has the company agreed to fund an outside expert for the Carver Fire Department to review the HMA and make sure it complies with everything they need?
So as a condition of our site plan review and special permit, and in coordination with the response that Ms. Sand provided earlier, it is absolutely our requirement to ensure that independent third-party fire protection engineering firm does review all our deliverables to the Carver Fire Department to allow them to make an assessment on the project.
Very good. Thank you. That completes the company's redirect.
Thank you. I believe that concludes the questions for the panel for Cranberry Point. And with that, we will conclude the hearings for today. I'd like to remind everybody that on Monday at 10 a.m., we will reconvene for intervener testimony and cross-examinations of intervener witnesses. Also, prior to that, as we've just decided, we'll have Mr. Kaiser available for questions, or possible questions in the morning. First thing, so that'll be the first order of business on Monday, and then we'll move on to the intervener testimony and cross. Okay?
Thank you, Mr.
Great. So,
Presiding Officer.
Thank you.
You're welcome. Everyone have a nice weekend when we're off the record.
too.